House will come to order. Members will please take seats. House come to order. House will come to order. Mr. Clerk, will you ring the bell, please? House will come to order. Members will please take your seats. Members, please take your seats. We're ready to go. Chairman Hatchett is recognized for a motion. Chairman Hatchett. Members, please give the gentleman in the well your opinion. Your opinion. No, I know you'll give me your opinion. Give me your attention. That's the one I'm talking about, your attention.
Thank you, Mr. Speaker. I think we probably all have an opinion. I move that this House adopt the committee conference report for House Bill 915.
Representative Hatchett moves that the House adopt the Committee of Conference report on House Bill 915. Mr. Clerk, will you read the Conference Committee report?
The Committee of Conference on House Bill 915 recommends that both the House of Representatives and the Senate recede from their positions and that the attached Committee of Conference substitute to House Bill 915 be adopted. Respectfully submitted for the House, Honorable Matt Hatchett, Representative of 155th District, Honorable Jan Jones, Representative of the 47th District, Honorable Penny Houston, Representative of 170th District. For the Senate, Honorable Blake Tillery, Senator of the 19th District, Honorable John F. Kennedy, Senator of the 18th District, and the Honorable Steve Gooch, Senator, 51st District.
Chairman of Appropriations, Chairman Matt Hatchett, is recognized to explain the Committee of Conference report on House Bill 915. Mr. Chairman.
Thank you, Mr. Speaker. First off, I want to thank our House conferees, Madam Pro Tem Jan Jones and Chair Lady Penny Houston. Mr. Speaker, I know we got a long day and we're racing towards crossover this week, so I'll keep my remarks to a minimum. Even though the budget before you is historic in size, representing more than $5 billion in new revenue, the final conference committee agreements that you see before you aren't really that different than the original document that passed this House just a few weeks ago. The budget was placed on your desk at 12:07, not long after the conferees signed the document, and I trust that you've had time to review the relatively few conference agreements. I'd like to mention a few of the highlights. Before we talk about the changes agreed to in the conference committee report, I'd be remiss not to begin with a few of the governor's recommendations that this House and Senate agreed with. An unprecedented $500 million strategic investment in the employees' retirement system to improve the funding ratio and the long-term financial viability of the system. $300 million to provide a one-time salary supplement of $1,000 for all state employees and teachers to continue efforts to improve and stabilize the state's workforce. $66 million for the Board of Regents to backfill prior reductions from the FY24 original budget. $102 million for the Department of Education to recognize enrollment growth and continue to fully fund QBE. And $250 million for the Georgia Fund in GEFA to support water and wastewater infrastructure developments in your local communities through low-interest loans. There are a number of items where the Senate agreed to fund the House priorities. In support of mental health, the Senate agreed to $475,000 in additional funding in DBHDD for the Georgia Housing Voucher Program. $750,000 to provide alternatives to sheriffs transporting those in mental health crisis. $664,000 to provide an additional jail-based competency program in Dodge County. $15.5 million to fully fund the construction of a new Gateway Child and Adolescent Crisis Stabilization Unit in Savannah. And $60 million to address urgent and significant capital needs across the state's regional hospital campuses. For public safety, the Senate agreed with the House to fund a $2 per diem increase for county correctional institutions effective April 1st. Eliminating contraband at our state prisons is a priority of this governor and both chambers. Working together with our Senate colleagues, we were able to provide $19.7 million in new funding for additional security measures at prison facilities statewide. These funds will be used immediately to begin implementation of these protection measures. The House and Senate agreed to provide the Department of Agriculture with $100,000 in planning money and $37.5 million for renovations and improvements at the Atlanta Farmers Market. This budget establishes the Georgia Farmland Conservation Fund with $2 million to provide matching grants to support farmland conservation, food and farming production, or the purchase of agricultural conservation easements. Both the House and Senate support the governor's recommended infusion of $1.5 billion for transportation and agreed to $98 million in additional airport aid, $593 million in capital construction to expedite the existing project pipeline, $50 million in capital maintenance for immediate resurfacing needs, $500 million for freight and logistics infrastructure projects, $250 million for local transportation projects, and $8.5 million for rail projects to continue upgrading our state's short line railroads. In pre-K and K-12 education, the Senate agreed to fund the summer transition program in DeKalb at its current level of service. The summer transition program provides rising pre-K students and rising kindergarten students with extra support in language, literacy, and math to close the achievement gap. The Senate agreed to fund communities and schools with a $1.57 million increase to leverage grant funds and expand the program to 10 additional school districts. To support health, the Senate agreed to $250,000 for a new FQHC startup grant in Cobb County. Finally, an item that I know is important to many in this chamber, the Senate agreed to provide $1.55 million to support the development of exhibits for the Anne Frank Education Center. There are a few items of note that were not funded in the House version of the budget that your conferees have agreed to include. $250,000 for the Department of Agriculture for equipment and vehicles to begin implementation of the Georgia Electric Vehicle Charging Program. The House version had recommended a delay, and the conference position allows the department to proceed with implementation on a smaller scale than initially recommended. $2 million for one-time grants up to $500,000 for the development of programs of all-inclusive care to provide home and community-based services. A recognition of $10 million in existing federal funds to be used for character education programs in local school systems. $300,000 to provide nursing faculty loan repayments. This addition helps support the nursing education pipeline by incentivizing nursing faculty to teach instead of work in the field where they may make more money. $75,000 to support the development of a donor breast milk bank. Georgia is the only state in the Southeast without a milk bank. This innovative program will allow Georgia moms to provide life-saving support to premature infants in Georgia NICUs. $4 million to cover subsidized state health benefit plan benefits to retired, injured in the line of duty officers at the Department of Public Safety. These state troopers were injured in service to our state, and many still have ongoing medical bills as a result of their injury. Their current SHBP premiums are exceeding their retirement benefits based on their years of service. The House fully supports this add. It just came to our attention too late in the process for us to include it in our version. $250,000 to the State Elections Board to support investigative operations. This function was first funded in FY24 budget, and additional support is needed. Finally, a late-breaking and one of the most exciting items for me personally in this budget is the forthcoming changes, or are the forthcoming changes to the Capitol complex. Earlier this morning, the governor revised his revenue estimate for the amended budget by $392 million to allow for renovations and improvements to the Capitol complex. Last year, in the budget, we asked the Georgia Building Authority to conduct a space utilization study to assess the needs of members and staff in the legislative function. The resulting study concluded that new and upgraded space was needed to effectively conduct legislative business and serve the public. I want to thank Gerald Pilgrim for spearheading this project. You know, a lot's changed since this building opened in 1889. You don't have to take my word for it. Just ask Terry England. He was here. Just making sure y'all are paying attention. In all seriousness, I don't have to tell you that we're bursting at the seams in this Capitol and across the street in the CLOB. This budget provides a once-in-a-lifetime opportunity to pay cash in the full cost to protect the safety and security of building occupants and improve public access to the Capitol Hill complex, with the construction of a new legislative office building, as well as over $83 million to restore the historical integrity of this building that was built so long ago. The Legislative Services Committee, which is comprised of members of the majority and minority parties from both chambers, recently voted to support this project, and we thank the governor for bringing the revenue to make it possible. While I didn't hit every item, I certainly did hit highlights, and there are many. The budget process, the budget is a process, and I'd like to thank Rick Dunn with OPB and Chairman Tillery for the spirit of collaboration in buttoning up this budget, as well as the staff of both the House Budget and Research Office and the Senate Budget and Evaluation Office for crafting the document that you have before you. There's much to be proud of in this budget and much good that is being done with it. I urge your favorable consideration of the Conference Committee report, the House Bill 915. And Mr. Speaker, I will try to answer any questions.
Gentleman yields for questions. To your left, Representative Kelly has a question. The gentleman is recognized for a question.
Thank you, Mr. Speaker. Will the chairman yield?
Yes, sir.
Mr. Chairman, isn't it true that one thing we've heard is there's a need in Georgia for more CDL drivers?
Yes, sir.
And isn't
I
it true?
experience that on I-16 quite often.
Thank you, Mr. Chairman. Will you yield for one more question?
Yes, sir.
And isn't it true that the over $5.5 million that this budget provides for Chattahoochee Technical College in Dallas will help us meet those needs in Northwest Georgia?
You are exactly right. Thank you.
Thank you, Mr. Chairman.
Gentleman, further yield.
Yes, sir.
Leader Beverly, right in front of you, has a question. Leader Beverly is recognized for a question.
Thank you, Mr. Speaker. The gentleman yield.
Yes, sir.
I'd like to bring your attention to Section 16, Community Affairs Department, more specifically 80.1000. Is it not true that the increase in the one-time community improvement grants for $2,500,000 was set aside potentially for Democrats for small dollar amounts to take back to the community to show that they're working on their behalf? Is that not true that that was included in our budget?
Yes.
Further question.
Yes, sir.
Is it not true that it's been disregarded again as it comes back across the aisle?
So
That there's no money to be found for the Democrats who painstakingly brought this to your attention so that we could do what we need to do for our communities?
So we worked with the Senate and with the governor's office and Department of Community Affairs to try to work this program out. We could not come to a successful conclusion on how to make that work. So I will be glad to discuss other options that may be in this budget that you see now.
Thank you, Mr. Chairman. I will only ask for you to consider in the 2025 budget that we have a more robust discussion that is based on integrity, and the members in this House can take back to their districts something that we say we fought for as well.
Yes, sir. Be glad to.
Thank you.
Representative Panich, to your left, out in front of you, has a question. The lady is recognized.
Thank you, Mr. Speaker. Does the chairman yield?
Yes, ma'am.
Mr. Chairman, I'm referring you to 367.49,
Yes.
the cut for $450,000 on the Georgia Commission on the Holocaust. It was a request of $2 million, and the give was 1.55.
Yes.
Does the gentleman further yield?
I didn't. What did you?
Do you understand? I mean, are you aware that anti-Semitism has increased 360% since October 7th?
Yes.
Do you believe now is the right time to cut Holocaust budget?
I
Why-
don't. Well, I don't believe this is a cut. I believe this is an add of $1.55 million for the exhibits to the Anne Frank, to the commission for the Anne Frank Center.
Does the chairman yield?
Yes.
The request was $2 million, correct?
I think the request was actually $4 million, and we had put into, and after the conference, in conference with the Senate and with the governor's office, this is what was agreed upon. It's still an addition of $1.55 million.
I have one more question.
Yes.
If the gentleman would yield. Isn't it true that Governor Kemp has been very proud of the $16 billion surplus he has? And can't we use some of that to continue Holocaust education?
I think we should all be proud of that additional money that's out there, and I look forward to seeing this investment used wisely.
Thank you.
Mr. Speaker, with
You
that.
have one more, Mr.
Okay,
Chairman.
I'll take one more.
Chair Lady Lynn Smith, right out in front of you up the aisle, has a question. Chair Lady Smith.
Thank you, Mr. Chairman, for this budget. Does the chairman yield?
Yes, ma'am.
Is it not true that this Capitol is considered the people's house for the state of Georgia?
Yes.
Is it not true last week, if anybody tried to move in this building last week, we couldn't and we would not have made a fire exit? Is that not true?
That is 100% true.
Is it not true that the money the governor has put in this budget is going to help us as legislators, but it is opening this hallowed building to the people of the state of Georgia, and I commend all of you for this effort. Thank you.
Yes, this money will allow for the preservation of this historical building for years to come, and will make it much more safe for everybody that visits and does business here. With that, Mr. Speaker, I'll yield the well and ask your favorable consideration.
The gentleman has yielded well. Thank you, Mr. Chairman, for your work. Members of the Conference Committee and members of the Appropriations Committee and all members that have had conversation working on this budget. On the adoption of the Conference Committee report on House Bill 915, all in favor of the adoption of the Conference Committee report will vote yes. All those opposed will vote no, and the clerk will unlock the machines. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the adoption of the Conference Committee report on House Bill 915, the yeas are 169, the nays are 2, and the Committee of Conference report is adopted. For what purpose does Chairman Hatchett rise?
Mr. Speaker, I move that the Conference Committee report on House Bill 915 be immediately transmitted to the governor.
On the gentleman's motion, Chairman Hatchett moves to immediately transmit House Bill 915 to the governor pursuant to Article 3, Section 5, Paragraph 8 of the Constitution. Mr. Clerk, will you read the caption?
The Committee of Conference on House Bill 915 recommends that both the House of Representatives and the Senate recede from their positions, that the attached Conference Committee substitute to HB 915 be adopted.
On the gentleman's motion that the House immediately transmit House Bill 915 to the governor, all those in favor will vote yes, those opposed will vote no, and the clerk will unlock the machines. Have all members voted? All members voted. If so, the clerk will lock the machine. On the gentleman's motion for immediate transmittal to the governor of House Bill 915, the yeas are 170, the nays are 0, and the House has voted to immediately transmit House Bill 915 to the governor. Members, we have a couple of motions we're going to take up now, and then we're going to get right back on the rules calendar. For what purposes, Chairman Jaspers rise?
Thank you, Mr. Speaker. I'd like to make a motion
State your motion.
that House Bill 1312 be moved from the Technology, Infrastructure, and Innovation Committee to the Transportation Committee. Both chairmen agree.
Mr. Clerk, will you read the caption?
House Bill 1312 by Representative Jaspers and others to be entitled an act to amend an act relating to the regulation and taxation of electricity used as motor fuel and electric vehicle charging stations.
On the gentleman's motion that House Bill 1312 be withdrawn from the Technology and Innovation Committee and recommitted to the Transportation Committee, is there objection? Hearing none, is so ordered. For what purpose does Representative Williamson rise? Wait a minute.
To make a motion,
State your motion.
I move that House Bill 1023 be recommitted to the Ways and Means Committee.
Mr. Clerk, will you read the caption?
House Bill 1023 by Representative Williamson to the 112th to be entitled an act to amend Article 2, Chapter 7, and Title 48 of the Official Code of Georgia, annotated relating to imposition rate computation exemptions and credit relative to income taxes.
On the gentleman's motion that House Bill 1023 be withdrawn from the calendar and recommitted to the Ways and Means Committee, is there objection? Hearing none, is so ordered. For what purpose does Leader F. Stration rise?
Speaker, I move that the rules of this House be temporarily suspended so that a bill may be read for the first time and assigned to committee.
Mr. Clerk, will you read the caption?
Unnumbered House Bill by Representative F. Stration to the 104th to be entitled an act to amend Chapter 3, Title 8 of the Official Code of Georgia, annotated relating to housing generally so as to establish a stable housing accountability program.
I thought you were going to move to adjourn there for a second. On the gentleman's motion that the rules of this House be temporarily suspended so a bill can be read for the first time and assigned to committee, is there objection? Budget and Fiscal Affairs Oversight. For what purpose does Chairman Parsons rise?
Thank you, Speaker. I rise to make a motion.
State your motion.
I move that the rules of the House be temporarily suspended so that a bill can be read for the first time and assigned to committee.
Mr. Clerk, will you read the caption?
Unnumbered House Bill by Representative Parsons, the 44th to be entitled an act to amend Title 46 of the Official Code of Georgia, annotated relating to public utilities and public transportation.
On the gentleman's motion that the rules of the House be temporarily suspended so a bill can be read for the first time and assigned to committee, is there objection? Energy, Utilities, and Telecommunications. For what purpose does Chairman Leverett rise?
To make a motion.
State your motion.
Mr. Speaker, I move that the rules be temporarily suspended so a bill may be read for the first time and assigned to committee.
Mr. Clerk, will you read the caption?
Unnumbered House Bill by Representative Leverett of the 123rd to be entitled an act to amend Chapter 1 and Title 51 of the Official Code of Georgia, annotated relating to general provisions relative to torts.
On the gentleman's motion that the rules of the House be temporarily suspended so a bill can be read for the first time and assigned to committee, is the objection? Public Health. For what purpose does Chairman LaHood rise?
To make a motion,
State your motion.
I move that the rules be temporarily suspended so that a bill may be read for the first time and assigned to committee.
Mr. Clerk, will you read the caption?
Unnumbered House Bill by Representative LaHood of the 175th and others to be entitled an act to amend Chapter 70 and Title 36 of the Official Code of Georgia, annotated relating to coordinated and comprehensive planning and serviceability by counties and municipalities.
On the gentleman's motion that the rules of the House be temporarily suspended so a bill can be read for the first time and assigned to committee, is there objection? Governmental Affairs. For what purpose does Representative Lott rise?
To make a motion,
State your motion.
I move that the rules of the House be temporarily suspended so that a bill can be read for the first time and assigned to committee.
Mr. Clerk, will you read the caption?
Unnumbered House Bill by Representative Lott of the 131st being titled an act to amend Code Section 31-2A 18 of the official code of Georgia annotated relating to the low THC oil patient registry.
On the lady's motion that the rules of the House be temporarily suspended so a bill can be read for the first time and assigned to committee, is there objection? Public and Community Health. For what purpose does Representative Gaines rise?
To make a motion,
State your motion.
I move that the rules of the House be suspended so a bill may be read for the first time and assigned to committee.
Mr. Clerk, will you read the caption?
Unnumbered House Bill by Representative Gaines, the 120th to be entitled an act to amend Chapter 1 of Title 35 of the official code of Georgia annotated relating to general provisions for law enforcement officers and agencies.
On the gentleman's motion that the rules of the House be temporarily suspended so a bill can be read for the first time and assigned to committee, is there objection? There is objection. The gentleman objects to the rule. The bill being read for the first time and assigned to committee. Does the gentleman move? He moves. All right, here's our posture. All in favor of suspending the rules so a bill can be read for the first time and assigned to committee will vote yes. Those opposed will vote no, and the clerk will unlock the machines. Have all members voted? If so, the clerk will lock the machine. On the motion to suspend the rules, the yeas are 98, the nays are 70. The motion to suspend the rules so a bill can be read for the first time has failed. It requires a 2/3 vote to move forward. So the bill has failed. It will have to be read as a first reader tomorrow. For what purpose does Chairman Todd Jones rise?
To make a motion,
State your motion.
pursuant to House Rule 57, I request to disagree to the committee report on House Bill 1244.
The gentleman has requested via House Rule 57 to disagree to the committee report on House Bill 1244, and that request be referred to the Committee on Rules. It is so ordered. Hope y'all are done. We'll move on to the rules calendar. Mr. Clerk, will you read the caption of House Bill 1172?
House Bill 1172 by Representative Burchett of the 176th and others to be entitled an act to amend Chapter 8 of Title 44 of the Official Code of Georgia Annotated relating to water rights so as to remove references to the public trust doctrine. This bill then referred to the Committee on Judiciary. That committee recommends that this bill do pass by committee substitute.
Whip Burchett is recognized to present the bill. If the gentleman will step down for a minute. We're moving on the rules calendar. I'm sure you want to hear what the gentleman in the well has to say. If you don't, you can go to the ante room, or that one, or out front. Chair recognizes Whip Burchett to present the bill.
Thank you, Mr. Speaker, and thank you, colleagues. I come to you to present a very simple bill. That is not the case. I have learned in the this past year more about navigable waterways than I care to know in the rest of my life, frankly. But I'm going to give you a little history about the bill and what the bill does. You can recall, sine die of last year, we passed a bill, Senate Bill 115. And what the bill sought to do was to enshrine the public's right to hunt fish in navigable waterways. Now, one of the things I want to point out for you all is this. Navigable is a defined term in statute. It doesn't mean that you can just float. If you can float, that's common term, not navigable, but the statute has a very different term. You must be able to conduct commerce up and down the river at least some portion of the year. So what Senate Bill 115 did was introduce one of these doctrines. It introduced the public trust doctrine. And over this past year, we had a special study committee to study this issue because it is a complex issue. The problem that came out of, the recommendation that came out of that study committee was this. The recommendation was to remove the words public trust doctrine from Senate Bill 115 while retaining the underlying purpose of Senate Bill 115. And that's what this bill, 1172, seeks to do. One of the other recommendations was to bring clarity to whether or not you can trespass on somebody's property when floating down a navigable waterway. So that is another provision that we added into this bill. So you all know that I'm a fan of the language in the bill, and so I'm going to run through the bill and try to explain to you what the bill does and why the strikes were made. First thing I want to say to you is this. Nothing in this bill does anything to impact non-navigable waterways, right? There's a distinction here. It's a property rights distinction. A navigable waterway, the property owner typically owns from the low water mark back. In a non-navigable waterway, they typically own to the center of the thread. Why is that important? Because if you own to the center of the thread in a navigable waterway, then perceivably you own the stream bed. And then there may be a problem with you walking and being on the stream bed. So nothing in this bill changes what you can do on a non-navigable waterway. So you'd likely been talking to or getting emails and text messages from folks in the paddling community, and they testified in committee, and their testimony was that you're taking away our rights. Well, the law as it stands today, and if 1172 passes, is that non-navigable waterways, if you're hunting, fishing, or floating, you're doing it at the permission of the property owner. You're not doing it at a right that was given to you by the state or a right that we've claimed. That's a fact. That is how the law sits right now today, okay? And so I want to make that clear because everybody has come to me with the questions with regard to non-navigable waterways. This bill only impacts or affects navigable waterways. So going through the bill, the first recommendation was we struck the language for public trust doctrine, and that's what happens on lines 11 through 15. Well, on 16 through 19, we recited how this is what I like to call a conclusion of law in Senate Bill 115. We concluded in Senate Bill 115 that we had the right, and we utilized the public trust doctrine as the means for saying that we had that right. Here on 17 and 18 and 19, we recite the fact that the state retains the ownership of the beds, but it's important to note in Senate Bill 115 that we delineated where the state owned the beds. If you had a pre-1863 grant, so a Crown's grant, before the state inherited the land or took the land, then you have a superior right. This is just common property law. You have a superior right. So you got your rights to the stream bed prior to the state could even get the rights or give away the rights. So in the event, and you guys recall, all of this stemmed from a piece of litigation that has now settled. And the litigation was that the owner had a pre-1863 grant and had exclusive rights to the riverbed, right? The settlement, as I understand it, and speaking with some of the parties involved, is that the settlement is that folks can continue to pass through. They have exclusive rights to the fish, and they have exclusive rights to the bed. That was an agreement between the state and this property owner. This does not impact that. So what we've done here is said that in a navigable stream bed, in a navigable stream bed, the right of hunting, fishing, and passage extends from low water mark to low water mark. So recall what I said at the very beginning. In a navigable stream, the property owner typically owns from low water mark back. So we've recited exactly what the right is here. You have the right to pass, you have the right to hunt, you have the right to fish in a navigable stream bed, no matter what. That's the only thing we've done. We've sought to clear this up. Now, I think you'll hear testimony about how do you fish or how do you hunt or how do you do any of these things without impacting the stream bed. Well, the fact of the matter is there is nowhere, not in Senate Bill 115, not in anywhere in statute, that anybody has said that you have a right to the stream bed. There's nowhere in code that you can find that or I can find that. If you can find that, please point that out to me. So what you're going to hear is that we're restraining the right. Well, we're not doing that. I can tell you from my perspective, I want to preserve the right to hunt, fish, and pass in navigable streams. I have a son that loves to fish for redbreast. I love to fish for redbreast. I'm not a big duck hunter, at least on the river, and I love to float and fish. So it's not a right that I want to constrain. What we want to do is clear up an issue that is cloudy, and it continues to be cloudy. We're trying to there's another companion bill I have with this, and you probably already had folks reach out to you for this. As I see it, this bill here, 1172, clarifies what your right is. The following bill is going to say where you can utilize that right. Basically a presumption of the state's navigable waters. The last piece of this bill is this. Nothing contained in this subsection shall construe to permit entry upon privately owned lands adjacent to navigable streams. I can sit here and tell you today that it has never been the intention of this General Assembly or anybody in this body that I know of that says that you should be able to float down a river, jump out of the river onto private property, and then sojourn, picnic, go hunt, do whatever you want to do. That was the biggest pushback or contention that I saw in the study committee. Folks saying, we're fine with people floating, we're fine with people fishing, we're fine with people hunting on the river, but we are not fine with people getting out of the river and going on the bank. And so what this provision seeks to do is clarify. Nothing in this law allows anyone to get out of the navigable waterway and go onto the property. There is a name for that. We've already defined that. What that is called is trespassing. That's all this bill does. And I've said a bunch, and I shouldn't minimize what I've said. This is not an easy issue. This is a tough issue. But I tell you folks, what we're doing here is clarifying an issue that is very cloudy, and part of the reason that we're doing this is because what we're having is altercations on a river or stream bank. You have folks, literally, I'll give you for instance, you have a father and a son floating down in a canoe, and you have a property owner shooting at them. Now you guys envision that. Now this is a real issue, and if we do not clear this up, you're just going to continue to have this problem. And there's going to be some pain in doing this, but I'm telling you, we have rewritten this language 15 times, no less, trying to appease everyone here. But ultimately, this is what you're doing. You're balancing private property rights with the right to hunt, fish, and pass. That's all we're doing here. And Mr. Speaker, I'm going to yield the well unless there are any questions. And
you have a couple of questions.
Very good.
Chairman Corbett, to your right, is recognized for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
Is it not true that the public trust doctrine is an area of law that has never been applied to our freshwater rivers and streams until SB 115?
Yes, sir, that is absolutely true, and I thank you for asking that question. The public trust doctrine is a doctrine that has history in the United States and in Georgia, but on the marshlands. Senate Bill 115 is the first time the public trust doctrine has ever been overlaid onto the fresh waters of the state of Georgia, to my knowledge.
Representative Mac Jackson. Chairman Jackson has a question to your right out in front of you.
Thank you, Mr. Speaker. Does the gentleman yield?
To my friend, I do. Yes, sir.
Is it not true that this was a learning experience on the study committee?
I agree. Yes, it was. Mm.
Further, do you further yield?
Yes, sir, I do.
Is it not true that this legislation will have no impact on the access rights of hunters and anglers, but will provide additional private property right protection to some Georgians?
That is absolutely true, and thank you, Mr. Representative Jackson.
Representative Nulowitz, to your left in the corner, has a question.
Does the gentleman yield?
Yes.
Is there any language in this bill that could be construed as taking or removing any existing rights that riparian landowners currently have?
No, and I thank you for that question. So it was posed to me that because we recited the right that you have on lines 21 and 22, for the second time we said, but in such cases the public's right is limited only to such navigable streams for passage and for hunting and for fishing. And it was posed to me that because we said that twice, that a judge may interpret it different than what the words say on the paper. But I don't believe there is any language in here that says anything other than what it says, that you have the right to hunt, fish, and pass on a navigable water.
Thank you for that clarification.
Thank you.
Chairman Meeks, to your right, has a question. Back in the corner.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
I just want to make sure that I'm hearing you correct. Nothing in this legislation prohibits or intrudes on my rights to fish on a navigable waterway. Is that correct?
That's correct.
Thank you, Mr. Thank you, Mr.
Thank you.
Thank you, sir.
Mr. Speaker, I can do this all day, but I will not. I'm going to yield the well.
Your choice.
Yes, sir. I yield the well.
You finally made a really good choice. Thank you so much. In the wisdom of the Rules Committee, they have limited debate on all of the issues before us this afternoon. So pursuant to House Rule 33.3, we have 30 minutes for those in favor of this proposition, 30 minutes for those opposed, and then 20 minutes for the chair's time and 20 minutes for a minority report. We'll begin with those opposed. You have 30 minutes, so there's 4 of you signed up to speak against the bill, so I will let y'all divide the time as y'all see fit. Representative Jenkins is recognized to speak in opposition to the bill. Representative Jenkins.
Members of the House, is. Mr. Speaker, friends, today I rise in opposition of House Bill 1172. I want to begin by saying how much respect I have for everyone who has worked on this issue, regardless of the position they take today, particularly to the whip. We don't see eye to eye on this, but he certainly worked this issue to try to get me on board, and I have the greatest respect for that. So it's with this spirit that I deliver these remarks to you today. Although 1172 affects all Georgia rivers, I will focus my comments on this issue to my river, the Flint River. And quite honestly, the way House Bill or Senate Bill at 115 came about last year, I think a lot of the stuff I'm saying today we probably would have already heard, but I want to make sure it's said in this chamber. Last year, the Monday before Sine Die, a lawsuit was settled by DNR between the state of Georgia and a property owner on the Flint River. This settlement created a procedure by which any landowner owning riverfront property in Georgia could exclude the public from the river. With the support of the governor's office, we passed SB 115 on Sine Die to correct this loophole created in Georgia law by this settlement. The bill guaranteed that the public would continue to have access to Georgia rivers, and I'm so grateful to everyone who made this legislation possible and each and every one of you who voted in favor of it. This was ironically the 50th anniversary of when then Governor Jimmy Carter sent a letter to the Corps of Engineers directing them to cancel the project to put dams on the Flint River and preserve this river in its natural state for the citizens of Georgia. To come to this conclusion, President Carter made several canoe trips down the river, one of which where he camped at Sproul Bluff. The Corps of Engineers evaluated that one of the primary benefits of this reservoir project was recreation. Carter disagreed. He assessed that there were 8 large reservoirs within 60 miles of this river. He also assessed that there was a rapidly increasing interest in recreation on free-flowing rivers, particularly in the Piedmont. It is the pressure from these very recreational activities that caused this river to be saved 51 years ago and that are causing us to visit this issue today. The decisions we make here today will determine if the river is available for the citizens of Georgia or if it will be lost to the public. The Flint River is truly special in that it's Georgia's only really natural river and one of only 40 rivers in the country that runs over 200 miles unimpeded. The fact that it is unimpeded by dams makes it a remarkable shoal bass habitat. In another ironic twist of fate, we're at another 50th anniversary. 50 years ago today, 50 years ago this year, the Georgia House attempted to move legislation to ask the Corps of Engineers to proceed with the reservoir project over the governor's objections. Although this measure passed the House, thankfully Governor Carter was able to stop this in the Senate, and he was again able to preserve this beautiful river for the citizens of Georgia, hopefully this time for good. President Carter assessed that saving the Flint River to be the most challenging task while he was governor, second only to the complete reorganization of the government. The effect of this was to cancel a hydroelectric dam project in the middle of one of the worst energy crises this nation has known. Every single chamber of commerce affected opposed canceling the reservoir project. He also had to fight the federal government. I ask each of you to consider this as you bear the pressure you feel from competing interests concerned with this. Last year, I sponsored House Resolution 519. This resolution was created before this settlement between the state of Georgia and the property owners on the Flint River and did not contemplate this settlement. I asked for this committee because of the issues that were developing on the Flint River with private landowners asserting rights over the river that I feel they didn't hold. This conflict, as the whip said, even escalated into gun violence with a landowner serving a prison term currently. I also asked for the study committee because Georgia law was vague, confusing, and contradictory on fishing access. Before the passage of SB 115, the Georgia legislature hasn't acted on this topic since 1863. The picture on the board here is President Roosevelt fishing at Flash Shoals near Gay. We have to recognize that Roosevelt was the president of the United States. He didn't just whip out an iPhone and snap this shot. It took a little work back then to take a picture. I feel that this location was chosen above all others since it was an iconic public fishing spot. This place was also where the Okefasuki Path, if I probably said that wrong, of the Creek Indian Nation crossed the Flint River since the shoals made a natural ford. The public has been on these shoals since before the state of Georgia as we know it today. We held the first River Access Study Committee a few miles from this location in Gay. Ruth Nash, the mayor of Gay, gave the first testimony at this hearing. Her family owned these very shoals at one time. She recalled how every Saturday these shoals were like the Six Flags of Meriwether County, with the rocks of the shoals full of people of the community enjoying the river. Since that time, this stretch of river has passed from her family's ownership, and the new owner has effectively barred the public from the river here. Not long ago, the Meriwether County Tourism Board, under threat of a lawsuit, was forced to remove any reference to fishing from all literature created from the newly created Flint River Water Trail. This river was set aside for the citizens of Georgia 51 years ago. Growing up in Fayette County, becoming an Eagle Scout in the Flint River Council, spending my summers at Camp Thunder, and then retiring from the Army to Meriwether County, this river has run through my entire life. I reject the false narrative that the Flint River is a private waterway. I know better. At the center of this discussion is 4485, the code section pertaining to rights of adjoining landowners to navigable streams. It reads, as used in this chapter, navigable stream means a stream which is capable of transporting boats loaded with freight in the regular course of trade. Mere rafting of timber, transporting wood shall not make a stream navigable. The discussion of this law during the committee hearing became a focus on how big the boat was that the legislature was talking about. At one point, it was nothing less than a coal barge being pushed by a tugboat. In interpreting any statute, we must presume the General Assembly meant what it said and said what it meant. Toward that end, we must afford the statutory text its plain and ordinary meaning, consider it contextually, etc. That's a passage from Deal versus Coleman, 2013. I won't read the whole thing. All that to say, the General Assembly did not say how large the boat must be. It was important that they would have if they thought it was important. And we cannot regard that specification to be an omission. Although the law doesn't speak of boat size, it does, however, speak in plain language to usage, traffic. It speaks of transporting freight for whole a part of the year, and it contrasts this to occasional use of a river, with floating logs and rafting lumber, something a landowner does once in a lifetime. The point is that in 1863, when this statute was passed, Georgia was in the middle of the Civil War, history's first total war where transportation and manufacturing became military targets, just like formations on the battlefield. Within a year, Atlanta would be under siege. The state was in a dire financial position and our transportation infrastructure was strained. Navigable waters, like any other thoroughfare, had to be maintained. This statute, and my whole point with all this statute directs resources to traffic, just like the General Assembly does today, and any other interpretation of this law ignores the text of the statute, the history, and it also ignores the history and customs of our state. I'll leave that out here. I'm gonna cut my comments a little short because I don't want to run out of time. So about a year after the passage of this law, the Georgia state government appropriated funds to facilitate navigability on the Flint all the way up to Three Forks, which is now beneath the Atlanta airport. Whatever boat they had in mind could make it up the Flint River all the way to that point. Another example of river commerce on the Piedmont can be found in the city of Campbellton in Campbell County. This county is the county seat, was moved to Fairburn in 1872, and this county was absorbed into Fulton County in 1931. This county seat had no railroad and relies solely on the Chattahoochee River for commerce. When this navigability statute was passed, the Chattahoochee from Campbellton to the shoals north of Columbus is where cargo was freighted, where it finished its trip by wagon. The statute directed resources and infrastructure to traffic, and in accordance with the statute and other laws and criteria, DNR has done just that in modern times, with boat ramps on the Flint River being about 4 to 16 miles apart from above flat shoals at Gay throughout the river to Lake Seminole, including the Upper Flint. I gave this historical context because another focus of the study committee became removing the public trust doctrine from SB 115. This doctrine is found in English common law. It's the foundation of the North American wildlife management model, and it's also stated explicitly in Georgia code relating to saltwater resources. At the request of industry stakeholders, I consented to this removal. However, this bill goes too far in other ways. First off, we do have a pending lawsuit on relating to SB 115. It was filed by an adjacent landowner. So there is currently a pending lawsuit that the state of Georgia is defending on this issue. We risk passing a bill that changes law that is the direct subject of a pending lawsuit. The bill also limits the use of navigable waters in an unprecedented way never before seen in the history of the state. It differentiates what the public can do on navigable waters based on whether the property owner owns the stream bed or not. This requires the boating public and fishing public to have a knowledge of property lines that they have no way to know as they float downstream. We deal with this same issue on our roadways. We have roads with deeded right-of-ways and others that run across private property. In the case of roads without deeded right-of-way, the public right to pass is based on the fact that the easement exists across private property. A person driving down the road cannot know who holds the deed of the property they're driving on and shouldn't have to care. The road that I live on begins as a deeded right-of-way, then turns into an easement, then turns back into a deeded right-of-way. Only I know where the transition occurs because I know what my plat looks like and I pay the taxes. And yes, I also, just like the owners of submerged land in the state of Georgia. The difference is, in recent years, our rivers have become far more precious than our dirt roads in the state, leading to this discussion in the General Assembly. Navigable waterways are the original highways of the state of Georgia, and they should be treated that way so that we have clarity and consistency in the law. Let's not taint this process and limit access because of unlawful activities on navigable waterways. Instead, we should focus on what is navigable and what is not, and exclude the public from places that are not navigable. In closing, I want to say that SB 115 was brought like all good legislation to solve a problem. It has been the law of the land for 8 months, and it really hasn't created any problems. As we consider HB 1172, we need to also consider the other things that this bill does other than remove the public trust doctrine from Georgia law. We need to focus on codifying a map of where the navigable waters in the state of Georgia lie, so that Georgians know specifically where they can pass in the state of Georgia. I want to thank the whip for dropping legislation to start that process. We cannot deny that Georgia is a very different place than it was in 1863 when this legislature last visited navigability. We have to recognize that the Georgia population has grown, and that this issue does deserve the attention of this legislature. I urge you to vote no for HB 1172, and with that, Mr. Speaker, I yield the well.
Gentleman is yielded the well. Representative Scott is recognized to speak to the bill.
Okay, thank you, Mr. Speaker.
You're good. Take your time.
Today, I stand before you to express my deep concerns about House Bill 1172, which aims to amend the Chapter 8 of Title 44 of the Official Code of Georgia Annotated, specifically targeting water rights. The bill proposes to remove references to the public trust doctrine, which is a fundamental principle safeguarding the interests of the public in accessing and enjoying navigable streams. Let us delve into why this amendment is detrimental to the rights of the citizens of Georgia and the integrity of our natural resources. First and foremost, the public trust doctrine rooted in the common law serves as a vital safeguard for the collective interests of the people in accessing and utilizing navigable streams. By removing reference to this doctrine, HB 1172 threatens to undermine the long-standing principles that navigable streams are held in trust by the state for the benefits of its citizens. This amendment essentially strips away the protection that ensure our rights to fish, hunt, navigate, and engage in commerce along these waterways. Furthermore, this bill attempts to limit the rights of Georgians by confining their access to navigable streams solely for passage, hunting, and fishing. By doing so, it disregards the multifaceted roles these waterways play in our lives and local economies. Navigable stream serves as corridors for transportation avenues for commerce and vital ecosystems supporting diverse flora and fauna. To restrict the public's interaction with these natural resources is to ignore the integral role they play in our state's heritage and economy. Moreover, by repealing laws that conflict with this amendment, HB 1172 disregards established regulations and legal framework that have been put in place to ensure the sustainable management of our water resources. This reckless disregard for existing legislation could lead to legal ambiguity and disputes over water rights, ultimately jeopardizing the delicate balance between environmental conservation and economic development. In conclusion, House Bill 1172 possesses a significant threat to the rights of Georgians to access and enjoy our navigable streams. By stripping away references to the public trust doctrine and limiting the scope of our interaction with these vital waterways, this amendment undermines the principle of equity, sustainability, and stewardship that should guide our management of natural resources. I urge you to stand against this misguided proposal and uphold the rights of the people to safeguard our waterways for generations to come. Thank you, Mr. Speaker, and I yield the well.
The lady has yielded well. Representative Long Tran is recognized to speak to the bill.
Thank you, Mr. Speaker. Today I rise to speak against this bill. If you take a look at lines 12 through 15, it removes the people's right to use and enjoy all navigable streams capable. I'm not going to read the entire thing. For the last 9 years, I have taken a Cub Scout pack down to Flint River for them to camp, to fish, and what I teach these kids is the air, the water, the fish, the deer, they belong to Georgians. They belong to the state of Georgia for our use and our enjoyment. This creates confusion. By removing those lines, the public doctrine, we create an imbalance to line 16, which provides a person who owns a crown grant. This is going back to the days of the monarchy. You know, we've had a revolutionary war that should have taken away the rights and given the rights to Georgians to use the air, the water, the fish. And so I have very strict concerns when it comes to Georgians using our streams. If you've ever seen 10-year-olds, 16-year-olds navigate our streams, the boats can be fairly large, they can be very small. Now, the kids I have taken down to Flint River, they come from all kinds of backgrounds, different economic backgrounds, different ethnic backgrounds. And one of my fears is the confusion this law will allow a person to say that he justifiably shot a kid just trying to enjoy our parks because he believed the kid was trespassing. I, as a former Scoutmaster, could not tell these kids what is navigable and what is not. This law is too confusing. So with that, I urge this body to vote no on House Bill 1172. Thank you, Mr. Speaker.
Gentleman has yielded the well. Representative Mary Margaret Oliver is recognized to speak to the bill. Representative.
Thank you, Mr. Speaker. I am a deep lover of the rivers and waterways of Georgia. I'm also a person who's made a long-time observation of the way in which this body interacts with that courthouse across the street. And we have had a long-standing rule, unwritten rule, but important rule, that we do not interfere with litigation that is ongoing about a policy position that is very important and complicated to us. The whip says that this bill is brought forward to clarify the recent chaos of the courts and the passage that solves certain chaos by the passage of Senate Bill 115. I say to my colleagues that this does not clarify an important issue. It further muddies an important issue. I have spent most of several decades in private practice on the square in Decatur, but all of my 20s I spent in North Georgia, rural Georgia, and enjoyed almost every one of the navigable rivers in a wide variety of rafting and kayaking. I rafted Bull Sluice on the Chattooga River, and if you don't know what that is, I'll tell you about it because it was an exciting day. Today, the last 23 years, I've owned property on Fightontown Creek in Fannin County. Fightontown Creek is a very important contributory of the Ocoee River, known as the Toccoa River, as it passes from Georgia into Tennessee. I have also spent most of the last 10 years on the Riverkeeper Board of the Altamaha River. So I have a lifetime of deep and abiding love for these rivers and waterways. The issue that I want to bring to you is the way in which we are further muddying waters that do not need to be muddied. Private shooting people on the Plint River is what began private litigation that resulted in a settlement, as the whip said, where private property owners made a deal that served their interest. And in response, the Georgia General Assembly, when that litigation was over in 2023, this body with the Senate came forward and passed Senate Bill 115. And when Governor Kemp signed that bill, he went to the trouble detailing why he signed it and highlighted the significance of the rights of hunting and fishing Georgia's waterways and the investments of tens of millions of dollars that the state has made. Some of you were here during Governor Sonny Perdue's fishing in Go Fish Georgia, and that has been a significant economic investment we have made. The whip says that that litigation was ended by the settlement, but the new litigation that we've talked about, again, is private property owners trying to sue the state to recover some of the rights that they believe they lost when we passed Senate Bill 115. The state of Georgia has made a motion to dismiss that lawsuit. So that issue is pending in court right now. We are sweeping in and trying to end that litigation in a way that is going to further complicate and make progress more meaningful. One of the things that distresses me about the use of 1172 is that it goes back and forth, in my judgment, between the issues of fishing and hunting and the issues of navigation and commerce. The common law right of public trust included commerce and navigation. And that is what's raised the complication of the issues about whether the kayaker that falls out of her kayak can get on the property safely to save herself and perhaps her children that are with her. We are taking a step here, despite an enormous amount of serious good work, to further confuse the issue that I believe was clarified by Senate Bill 115 with the help of the governor, was clarified with DNR's progress following 115, and taking a step that is unnecessary at this time. I am further concerned about, let me go back to us interceding in litigation that's ongoing. I think that the interpretation that private property owner is trying to make in court that has been, the state has moved to dismiss, is litigation, if it was allowed to go forward, would further assist in the strength that we brought forward to help fishermen and hunters of Georgia through Senate Bill 115. This effort is not simple. It is further muddying waters that don't need to be muddied under a traditional respect we have for not interfering with ongoing litigation. And I ask you to vote no on 1172 for the purpose of giving further security to the hunters and the fisher people of Georgia, and also for the respect that our governor has given to Senate Bill 115. Thank you, Mr. Speaker.
Thank you, Representative Oliver. The lady has yielded the well. That concludes those opposed to the bill. We'll now recognize those in favor, and we'll recognize Representative Al Williams from down on the coast to speak to the bill. Representative Williams, you're recognized.
Thank you, Mr. Speaker. For reasons that some of you know, I was reluctant to come down today because of some things happened in my personal life, but it's certainly important, I feel, to speak to this bill. Now, I served on the study committee. We went all over, mostly North Georgia. And my first day there, it just occurred to me when I was in my hotel room that God has a great sense of humor. I thought about it. I said, Lord, back when the Crown grants and the state grants of 1863 were done, I didn't have a shot at not one piece of this land. I couldn't get me a piece of land. And now, Lord, you've put me here to help make a decision. And I got really tickled. It was doubly as funny, being one of only two Democrats, Representative Jackson and myself. I think at first I felt kind of like the Indians felt when they owned all the land up there. Must have been some kind of feeling to leave that beautiful land and go, but they had to go. They didn't leave voluntarily. So I had a lot of mixed emotions. But you know, whenever you start talking about property rights, it's a lot of passion on both sides. It's a passionate subject. And I like to break things down. Calvin Smyre used to say, don't talk to the giraffes, talk to the goats, and everybody will understand it. So in my southeast Georgia way, I have an analogy. I live on Highway 84 in Midway, and those of you that live down there know that Savannah is a bedroom community of Midway. I thought somebody get that after a while, Speaker.
That's a joke there. Y'all didn't get it.
But where I live is exactly 6 miles from where Interstate 95 crosses 84. And in those 6 miles, there is a McDonald's on the left when you head my way. You can buy a Big Mac, some French fries, and whatever else, and a milkshake. And the average person can finish eating it by the time they get to my house. And every weekend when Libby and I get home, the first thing we have to do is clean up the ditch with all the mess from McDonald's. And where it ends up does happen to be private property. I don't have a problem with the rights, everybody. The air certainly belongs to Georgia. The only thing is, once you leave the air and the stream, that's not yours up on the bank. And anybody that has ever been in anything public in Georgia knows how it looks after people stop and enjoy themselves. Very few people say, let me police this place up and leave it like I found it. How would you like to own a home on a beautiful stream and wake up every morning having to clean up? Be safe. Navigable waters are open to everybody. Catch all the fish you want. It's another thing that bothered me, Mr. Speaker, while I was on this committee. Traveled everywhere, saw some of the most beautiful trout in the world. Never got a real piece of trout the whole time. They got a little embarrassed up in Blue Ridge and fixed me some trout dip. And I ain't a dip eater. I wanted a piece of fried fish. But why is it so hard to understand that you would want the beauty of your property preserved if you lived on the river? Navigable means the ability to move commerce unimpeded. And the navigable river, those that want to enjoy it can enjoy it, but it does not give you the right to move on to private property. Now, I didn't grow up living there, hadn't visited much. I mean, Representative Jackson and I were in North Georgia. You can understand why I didn't visit much, didn't get many invites, and sure didn't have nobody kin to me up there. And as I sat around and looked at folk fight over this navigable water and private property, it wasn't very diverse up there either. We didn't have a local chapter of NACP up there. So it was pretty well established that when the Indians left, that was the end of the minority folk. But I defend the right of those to have private property and the right to determine how it's kept. We've gotten it all twisted. We can make anything. I had a friend of mine say, wherever there's a mess, he knew somebody that had a stick. And when you start with the mess and you're stirring it, you got a bigger mess, and land problems are a mess. I don't like having to stand here in opposition to some of my most respected members of the Democratic Party, the minority. I don't like it. But I served on that committee, and I did not oppose the resolution of the committee, and if I had opposed it, I would have been the first to speak against it today. But I'm not a hypocrite. I voted to move this recommendation forward into legislation. 115 needed some straightening, and hopefully it will. Listen, it's never really going to be truly straight. The only thing more complicated than private property is cosmetology in Georgia. It's just tough. It's heavy lifting. But I'm here to ask you to think about the protection of private property and think about me and Paul Libby out there picking up McDonald's paper wrappers on our property. And when you do, I would certainly hope that you would move to vote yes for 1172. It's a good piece of legislation. It's not the perfect answer, but it's the best we've put forth so far. With that, Mr. Speaker, I yield the well.
Thank you, Representative Williams. We appreciate your viewpoints. We do have a minority report, but is there any objection to the previous question being ordered? Chair has none. The previous question is ordered. We do have a minority report for up to 20 minutes. Representative Stacey Evans is recognized to speak to the minority report. So you can plan your day, members. Then we'll have 20 minutes for the chair's time after the minority report.
Thank you, Mr. Speaker. Good afternoon, colleagues. I am here today to speak in opposition to House Bill 1172. Before I get into the heart of my remarks, let's all think about a couple of things as I'm talking. Why are we here? How did we get here? What problem are we solving? Who are we helping? And who might we be hurting? If we could just keep those questions in mind. Why are we here? How did we get here? What problem are we solving? Who are we helping? Who are we hurting? Stepping back, Senate Bill 115 came to us because a landowner sued the state and said he had exclusive rights to fish a certain area because he owned a portion of the bed of the Flint River. Landowner sued the state, only I can fish here. It didn't have anything to do with the hilltop on the side of the beautiful river. It wasn't about trash being left on the hill. It wasn't about people being on that hill at all. It was about people fishing in the river, and the landowner said, no, only I have a right to do that, or only I have a right to give you permission to do that. That's what the lawsuit was about. Landowner sues the state. It was also not because an environmentalist sued a landowner and said that they were using too much water from the river for irrigation or anything like that. It wasn't. It was the landowner trying to stop people from fishing. Keep that in mind. That case settled just before sine die last year, and it led to understandable fear that other landowners were going to do similar things, that they were going to bring other lawsuits to try to block public access to our streams and our rivers. So enter Senate Bill 115. Senate Bill 115 was a simple bill. There's not always simple bills. This one certainly isn't, but Senate Bill 115 was. It just stated that under the public trust doctrine, the public retains the right to fish, hunt, and transit our navigable streams, even where the title to the stream bed maybe belongs to a private party, that private party has the bed, but in public trust. So you can own the bed, and it's yours, but you can't keep the public from being in the water, standing on the bed while they're fishing, things of that nature. That's all it did. So after we passed Senate Bill 115, it's been mentioned here, there was another lawsuit by another landowner saying that they owned the bed of the river of another section and also wanted to prevent public fishing there and challenging Senate Bill 115. So again, landowner suing the state, trying to keep people from fishing, not an environmentalist, not somebody suing about trash on the hill. No one disputes that, ladies and gentlemen. None of these bills, either Senate Bill 115 or this bill, is about trying to keep people from walking up the hill while they're fishing. It's about being able to stand in the stream, perhaps. Maybe your fishing pole hits the bottom of the stream bed while you're in the water. So how did we get here? So the study committee made the recommendation to remove reference to the public trust doctrine. That was really it from the study committee. So anybody who was on the study committee and you want to stay true to what you did, voting against House Bill 1172 doesn't make you a hypocrite, because the study committee just said remove reference to public trust doctrine. House Bill 1172 does so much more than that. Now, even this public trust doctrine thing, I don't really understand the concern there, but I know that the study committee wanted to make sure that farmers and everyone was satisfied that this wasn't going to open the door for environmentalists or others to sue them and say, you're taking too much water from the stream, the public trust says you can't do that. There was a case in North Carolina that folks were concerned about. This fear was unfounded, and we can talk about those reasons, but it doesn't really matter. I'm not opposed to removing reference to the public trust doctrine. That would be fine. I don't know anyone who's opposed to that, really, honestly, not much. What I am here to bring our attention to, and what I want you to focus on, is the study committee says remove reference to public trust doctrine, just re-emphasize that people have the right to go up and down these streams and fish and hunt, and if they touch the bottom while they do it, so be it. No one's going to be mad. But and you still don't get to go up on the hill, and no one's saying that you do. But what 1172 does is more. I was going to tell y'all about all the reasons why the public trust doctrine fears were really unfounded, but you don't need to know that because no one's against it, right? So we're just going to move to what is the what else of 1172. 1172 removes the public's right of transportation, commerce, and navigation on navigable streams. That is in lines 12 through 15. You'll see those words are deleted. The only words that ever come back are hunting and fishing. So that's, why did we do that? No one has told us that. House Bill 1172 establishes that the public has the right of passage for fishing and hunting on navigable streams, even where title in the beds is in a private, it belongs to a private party, but, and this is the part that's concerning, if you would look with me, I know this can be a little lawyerly here, so pardon me, but lines 21 to 23, if you could focus there for me. 1172 is trying to say that the public has a right of passage for hunting and fishing on navigable streams, even where title to the bed of the stream may rest with a private party. But then there's this caveated language in lines 21 to 23 that says, but is limited only to using navigable streams for passage and hunting and fishing, and doesn't mention the right to stand on the stream bed. Now, I doubt that I fish as much as many of y'all in here, but I don't think it takes a PhD in fishing to know that you probably need to touch the stream bed to effectively fish. So why is that caveat there to only talk about the use of the stream but not the stream bed? Taken on its face, the language limits the right of passage and hunting and fishing to only using the water but not the bed. Now, we've heard that this is not a big deal because Senate Bill 115 didn't really address the issue of stream beds either. Well, I disagree with that, but assuming for argument, at best, Senate Bill 115 was silent on this. 1172 is not silent. It has a specific carve-out that gives you the right to the water when you're fishing, but not the bed. Why? We heard at the beginning of the presentation here that we wanted to do two things today in 1172. Eliminate reference to the public trust doctrine. Okay, fine. Again, I'm not opposed to that. That's in lines 12 through 15. We can do that. But then we heard the second reason that we were here today for 1172 was to bring clarity about whether you can trespass. Now, I have read this bill 1172 way more times than I ever cared to. I don't see any, and backing up, the only thing about trespass that I've heard up here today is that you can't go up on the hill and have a picnic. You can't go and take a nap. I don't see one word in House Bill 1172 to clarify that the public has no access to the land to the left and the right of a stream. I don't see that. So the only way I can think of that 1172 clarifies where we can't trespass is that it's got a carve out that says I can be on the water, but I can't be on the bed. That's the only thing I can think of in 1172 that clarifies trespass. So if you're on the water, if you stay on your boat on top of the water, you're probably fine. But if your fishing pole hits the bottom or you get out and you've got your waders and you are touching the bottom, I think you're going to be in trouble. So, but if that's not the trespassing that we're talking about, then why can't we get clarity in the bill that it's the stream bed and not just the water? That's the question. And I've been asking it since committee. And I think it's helpful for folks to have the full context here. This bill barely made it out of Judiciary Committee. There was a tie, and the tie was broken in favor of moving the bill along. But we had a lot of debate. We heard from lots of people who enjoyed our favorite pastime of hunting and fishing and talked about how they wanted to have protections. Then we heard from the Georgia Wildlife Federation, Georgia Farm Bureau, Georgia Forestry Association, and Georgia Agribusiness Council. I asked every one of the representatives from those organizations what it was their members wanted to prevent that they didn't think was already covered by Senate Bill 115. The only thing I heard from any of those fine gentlemen that are there to represent these organizations was public trust doctrine. So I come back again. Why are we doing more? And if we're trying to clarify where we don't want people to trespass, why is there nothing in 1172 that talks about the hilltops? The only thing I can find, again, is that carve-out that says you can be on the water, but it doesn't include the stream bed. And I'm always searching for the why. And I know so many of y'all are in here like that. We know that these organizations that I've mentioned are wonderful organizations. I have the utmost respect for them. But we're all big boys and girls in here, and we know that these organizations always have the sportsman side, right? They have the folks that are there to protect the nature side of what these organizations are meant to preserve. But in everything, ladies and gentlemen, there is a business side. Who wants to charge you? Who wants to make money off of our favorite pastime, hunting and fishing? Ladies and gentlemen, that's what I think must be going on here today, because otherwise I don't know why we're not talking about the hilltops. I don't know why we've got this carve out, and I don't know why the Chamber of Commerce has put a letter on your desk urging you to vote for this otherwise nature-focused bill. Mr. Speaker, I yield the will.
Thank you, Representative, for yielding and your presentation. Now we have 20 minutes for chair's time. The chair of the committee from which this bill came, Chairman Gunther, is recognized to speak to the bill. You have up to 20 minutes, or you can share.
Thank you, Mr. Speaker. Well, there's been a lot said about the public trust doctrine, so I want to address that first. Senate Bill 115 was rushed through the process. It didn't appear until the last day, in the last hours, before it came in here to us for us to vote on. Not going through that process, the bill wasn't properly vetted. The term or phrase, public trust doctrine, there's been a lot of discussion about that. But what is the public trust doctrine? There is some common law on it. There is some Roman law on it. From what period of time are you talking about the public trust doctrine? And there's 50 states out there that have some sort of public trust doctrine out there. Which one does the state of Georgia go look to apply here? That's the problem with leaving public trust doctrine in this language. The courts will fill that void by going somewhere else looking for law to put in that. And it didn't need to be that way. That was the reason for the removal of the public trust doctrine. So what does this say? What you can do, what this bill tells you you can do, is you can go fishing on navigable streams. You can go hunting on navigable streams, although I'm not a hunter or a fisher. The only hunting and fishing I do is golf balls. So with this, you can go down the stream on a tube or a canoe or whatever kind of floating device you want. You can get out of that floating device and step onto the stream of the bed, and you can fish, as long as you're doing it for passage, hunting, and fishing. That's what this is. This is all about the navigable streams and what you can do on it. And if you look at it on lines, let's see, we'll start at the end of 16, where it says, the General Assembly further finds that by common law, the citizens of this state have an inherent right to use for passage and for hunting and fishing all navigable streams from low water mark to low water mark. So above the low water mark, the adjacent landowners own that land. You can't trespass on that. If you have a grant, a crown title or a state grant, you actually own the bottom of the river, the terra firma. So this is akin to an easement for the public. They have the right to go on there for passage, which means they can float through, If they get stuck on a rock, they can get out, move the boat, and continue their trip. Or they can do it for hunting or fishing. It is okay to trespass on the riverbed, the terra firma there, as long as you do it for these purposes. This bill simply clarifies what Senate Bill 115 started, and in my opinion, created a big mess. And that's why this bill is here. I would ask you for your support. I think it's a good bill. I think it helps clarify the law. We still have the issue of navigability that will come up later, but that is I think the remaining big issue on this discussion that we're having here. So with that, I'll yield the well. Oh, and yield my time to the Chairman, Whip Burchett.
The chairman has yielded the well, the remainder of his time to Whip James Burchett. Gentleman's recognized.
Thank you, Mr. Speaker, and I will be brief. I just come up here and do the rebuttal, right? And I've got to set the record straight as I see it. We had a presenter present that in lines 12 through 15 testified that we're removing the right. If you continue reading the bill, 17 through 19 says, Assembly further finds that by the common law, the citizens of the state have the inherent right to use for passage and for hunting and for fishing all navigable streams from the low water mark to low water mark. So where the gentleman is right, we did remove the right. We just recited it in another part of the bill. This ongoing litigation bar, I'm not sure where the idea came from, but a gentlelady was mistaken when she said that litigation had settled when we took up Senate Bill 115. Senate Bill 115 was passed last year. The settlement for that piece of litigation just happened a week and a half ago or 2 weeks ago. And also, I would submit to you all, if we didn't do anything that was under litigation, we wouldn't do anything in this House. We couldn't get anything done. We couldn't do nothing. There's so much litigation happening around the state on so many different issues. We wouldn't get anything done here if we couldn't legislate over litigation. The definition of navigation covers. It was said up here that this bill was not about people on the Hill. And I'm going to give my friend grace because she testified not being in the study committee and hearing the litigant say, the reason I'm bringing this litigation is people standing, drinking, camping on my property. That is the reason the litigation was brought. He specifically said that I don't care if they float down the river. But being up on the hill, just imagine this. I'm going to paint you I'm not a good painter, but I can speak it to you. Let me paint you a picture. You're sitting in your backyard on the Flint River with your family and friends, enjoying a Saturday, having some sweet tea or water or whatever it is you drink, and you've got 4 or 5 of my good friends on your bank in short cut-off jean shorts, no shirt on, drinking beer, casting, saying the most, talking like we talk on the river. Can you imagine that? I mean, this is literally about that. I mean, that's what the initiation of the litigation was, so the litigant testified. Lastly, I want to say, currently, the way the law stands right now, if we don't pass 1172, if you're on a non-navigable waterway, if you're floating, fishing, or hunting, then you're doing it at the permission of the property owner. This doesn't change that, doesn't touch that area law, it doesn't remove any right. All right. It was also said that this bill says nothing about trespass. And I want to direct you, because I'm a big fan of the words on the page, 24 and 25. Nothing contained in this subsection shall be construed to permit entry upon privately owned lands adjacent to the navigable streams. Specifically, testimony was next to the streams. Adjacent to me means next to the streams. You can't trespass on that land. Folks, we're overcomplicating an issue here. We're reciting what the right is. The right for Georgians to hunt, fish, and pass on navigable waterways, even where someone has a title pre-1863, you still have the right to hunt, fish, and pass. And with that, Mr. Speaker, I ask for your favorable consideration, and thank you. I yield the will.
Gentleman has yielded the will. That completes the discussion on House Bill 1172. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there an objection to adopting the committee's substitute? Chair hears none. The committee's substitute is adopted. Is there an objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And Mr. Clerk, will you unlock the machine? Have all members voted? All members voted. For what purpose does Representative Petrie rise?
Parliamentary inquiry, Mr. Speaker.
State your inquiry.
Mr. Speaker, is it not true that I'm a lifetime avid sportsman, hunter, fisherman, and boater?
If the gentleman so states, I know that's true.
And Mr. Speaker, is it not true that this body has long held that private property rights are fundamental to freedom in this state?
I'm sure the gentleman believes in what he states. For what purpose does Flor Leader McDonald rise?
Parliamentary inquiry, Mr. Speaker.
State your inquiry.
Is it not true that I had the privilege to go to our North Georgia mountains and listen to good Georgians that love to talk about and encourage people to hunt and fish, and watch them get entertained by the man that likes to pick up trash, McDonald's trash on the side of the road?
As long as it wasn't your trash, Mr. McDonald's, but...
Further parliamentary inquiry, Mr. Speaker.
State your inquiry.
Is it not true this issue's been studied for the better part of a year, and this legislation is the result of the diligent study?
I'm sure the gentleman knows what he speaks. It's been debated very well today. Now, have all members voted? If so, the clerk will lock the machine on the passage of the bill. The yeas of House Bill 1172, the yeas are 107, the nays are 60. The bill, having received the requisite constitutional majority, is therefore passed. Here we go. For planning purposes, I thought we could recess here at 3 o'clock. We're going to recess at 4 o'clock and go to our committee meeting. So we're going to take up a few more bills this afternoon. And so for you to plan your remainder of your afternoon and early evening, we will recess at 4 p.m. Yeah, we won't reschedule committees. We just push all committee meetings back now a total of 2 hours. All committee meetings are pushed back for 2 hours. Mr. Clerk, will you read the caption to House Bill 927?
House Bill 927 by Representative Hagan in the 156 to be entitled an act to amend Article 1 of Chapter 3, Title 27 of the Official Code of Georgia annotated relating to hunting so as to authorize fluorescent pink hunting outer garments. This bill having been referred to the Committee on Game, Fish, and Parks. That committee recommends that this bill do pass by committee substitute.
Since we're talking about hunting and fishing, I thought this may be appropriate time to hear from Representative Hagan as she presents House Bill 927. Representative Hagan is recognized to present the bill.
Thank you, Mr. Speaker. House Bill 927 if you're hunting, in some cases, you currently have to wear 500 square inches of blaze orange. This bill simply adds the option of wearing fluorescent pink if you choose to do so. This bill passed unanimously out of Game, Fish, and Parks Committee. It was subsequently recommitted back to that committee where it received an amendment That amendment is, it extends the sunset, allowing for the use of air guns when hunting in certain circumstances. Mr. Speaker, that is the bill, and I would ask for your favorable consideration of this measure.
The lady has a question.
I'll
She
yield.
yield for a question?
Yes, sir.
Representative Beverly, Minority Leader Beverly has a question right there in front of you.
Thank you, Mr. Speaker. Does the gentlelady yield?
I do.
We talked about this before, but there are certain colorblind anomalies that people have. And you could have a colorblind anomaly where you wouldn't be able to pick up the color pink, color red, color green, orange. Can you talk to me about how this bill would be impacted with folk who have colorblind anomalies?
Absolutely. Thank you for bringing that up, and I appreciate you the conversation that we had about that a couple weeks ago. We had a conversation about color blindness and how the color pink might impact someone who's colorblind if they're hunting. We did some research, and we found that it is true that with some types of color blindness, a person may not be able to detect the color pink. However, we also found that they cannot detect orange either. So our determination was that this bill would not negatively impact those hunting who chose to wear the color pink there, if it's fluorescent pink. And I do thank you for bringing that up.
Chair, lady yield for another question from the leader on the other side of the aisle, since they've been talking. Chair Leader Efstration, is recognized for a question.
Lady yield.
I do.
Thank you for bringing this measure. Isn't it true that this bill was brought because it was recommended? The idea initially came up from a 14-year-old student in the district that I represent, Carly, who had this idea. She's an avid outdoors woman, enjoys hunting. She had this idea and brought it to you for introduction this session. So this is not only great policy, it's been a great civic engagement opportunity for a young Georgian to see the legislative process work through. Isn't that true?
That is absolutely true, and I thank you for bringing that up. As a former middle school teacher, nothing makes me happier than to see a young person engaged in the process. And I actually mistakenly assumed that she did this research and brought this forward as a school project, but that was not the case. She simply is passionate about hunting and wanted to see this as an option should someone choose to want to wear pink instead of orange. So thank you for bringing that up, and I do thank her for all of her hard work in the research in bringing forward this idea. Mr. Speaker, if there are no other questions, I would yield the well and ask for your favorable consideration.
The lady has yielded the well. She did have one more question, but if she's yielded. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? All members voted. If so, the clerk will lock the machine. On the passage of House Bill 927, the yeas are 166, the nay is 1, the bill having received the requisite constitutional majority is therefore passed. Mr. Clerk, will you read the caption of House Bill 1078, 1078?
House Bill 1078 by Representative Petrie of the 166 and others to be entitled an act to amend Chapter 6 and Title 49 of the Official Code of Georgia Annotated relating to services for the aging so as to create a new adult day center licensure exclusion. This bill I have referred to the Committee on Human Relations and Aging. That committee recommends that this bill do pass.
Gentleman from the coast, Representative Petrie, is recognized to present the bill. Representative Petrie.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, many of you may know I spent my career up until 5 years ago when I sold, spent my lifetime trying to keep people out of institutions and serve seniors in the community and others with disabilities, particularly developmental disabilities. This bill I bring you today is a department bill by the Department of Community Health. It is the enabling legislation that allows community health to develop and implement a PACE program. Now, the PACE program, the acronym is Program for All-Inclusive Care for the Elderly. And so what this is a capitated program, an innovative program to provide all of the care that an individual needs in the community as they age in place and to avoid skilled institutional placement. So these individuals are all on Medicaid. They also are on Medicare. They're duly eligible. And so they're already entitled to nursing home care. When we serve them for less and give them a better quality of life by keeping them in the community, it's good for them and it's good for taxpayers. And that is what, indeed, this program is all about. I do want to mention that this program is already active in about 32 states. It's totally voluntary, so individuals choose this as a route like they do for other waivers, as an alternative to skilled institutional placement. And I do want to make sure that those of you know that initially there are 3 sites chosen, and that was done by an assessment that the department did starting last year. There's going to be a site in Atlanta, site in Macon, and a site in Savannah initially. And hopefully with success, they will move on to other areas of this state and continue to give people options to age in place when they are on Medicaid. Mr. Speaker, I think that fairly explains it, and I'm glad to answer any questions if there are any.
The gentleman has no questions.
Thank you, Mr. Speaker.
The gentleman yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Does Brett yet have something? Have all members voted? All members voted? If so, the clerk will lock the machine on the passage of House Bill 1078. The yeas are 165, the nays are 1. The bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption to House Bill 1218, 1218?
House Bill 1218 by Representative Leverett of the 123rd to be entitled an act to amend Article 1 of Chapter 5 of Title 53 of the Official Code of Georgia Annotated relating to general provisions relative to probate so as to provide notice to beneficiaries of a testate estate.
The gentleman from Elberton is recognized to present the bill. Representative Leverett.
Thank you, Mr. Speaker. Ladies and gentlemen, this bill fits in with the old expression of why do we meet every year? To fix the things we messed up the year before. 1218 is amending a statute that was created by House Bill 91, which we passed last year. That bill created a new section in the probate code to deal with situations or try to protect beneficiaries of estates when the executor that gets appointed absconds with the money. It would require executors to notify the beneficiaries when the executor is appointed. The main intent of the bill is still preserved, but the fiduciary section of the state bar and the probate judges requested certain changes to that statute to make it more effective and to strengthen it. So under the law as passed last year, which is set out in the bill, you can see there's parts of it are stricken. the executor would have to notify beneficiaries that the executor had been appointed within 30 days. This gives the executor more time, but it preserves the portion of the existing law that says that the executor can be cited and fined or removed for failing to comply with that requirement. We also try to clarify that notices don't have to be given if the beneficiary acknowledges that the beneficiary has been given a notice. So if the beneficiary just consents, you don't have to go through the formality of a notice. We address some other technical issues about how you would notify a trust. We also, again, we extended the time by which the executor has to report back. Under the old law, it was affirmative duty, or it was a procedural rule. Now it's an affirmative duty of the executor. So we think this makes it stronger, and the probate judges in the fiduciary section believe it's more workable within the existing framework of probate proceedings. So that's the gist of the bill. I will yield for any questions, Mr.
You have no questions.
Thank you. I'll ask your favorable consideration of House Bill 1218.
Gentleman's yielded the well. Is there any objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? Chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And the clerk will unlock the machine. Have all members voted? Have all members voted? If so, the clerk will lock the machine. On the passage of House Bill 1218, the yeas are 168, the nays are 0. The bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption to House Bill 1237, 1237?
House Bill 1237 by Representative Cannon and the 172nd and others to be entitled an act to amend Code Section 2811 of the official code of Georgia Annotated relating to definitions regarding agricultural commodity commissions. This bill has been referred to the Committee on Agriculture and Consumer Affairs. That committee recommends that this bill do pass.
The gentleman from down in Moultrie, representing Chaz Cannon, is recognized to present the bill.
Thank you, Mr. Speaker. I've been told to be brief, and I'll try to do that. This is House Bill 1237. This is a Department of Ag cleanup bill, short and sweet, for the Citrus Commodity Commission. In the original bill, it defined a citrus producer as someone that owns or operates at least 5 acres of citrus fruit-bearing trees. Soon after the new commission was formed, they determined that it would be much easier for them to quantify tonnage or weight as opposed to acreage. So what this bill does is simply remove the definition of what a citrus producer is under the commodity title, which is where it defined a citrus producer by acreage. And by doing this, it'll give some flexibility to the commission to spell out definitions of what is to be required to be a citrus producer in the marketing order rather than in statute. This method exactly mirrors that of the Blueberry Commodity Commission. So overall, a cleanup bill, it adds some clarity and some flexibility, and it's something that supports a growing industry for our state's #1 business. That's the purpose of the bill, Mr. Speaker, and I'd like to recommend this bill do pass. I'll stand for any questions.
Gentleman has no questions.
I yield the well, Mr. Speaker. Thank
He's
you.
yielded the well. I love my Satsumas. There's no doubt about that. Is there any objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? If so, the clerk will lock the machine. On the passage of the bill, the yeas were on House Bill 1237. The yeas are 166, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption to House Bill 808?
House Bill 808 by Representative Chokus of the 151st to be entitled an act to amend Article 2, Chapter 5 of Title 48 of the official code of Georgia annotated relating to property tax exemptions and deferral so as to increase the statewide ad valorem tax exemption. This bill having referred to the Committee on Ways and Means, the committee recommends that this bill do pass by committee substitute.
Chairman Chokus is recognized to present the bill. Chairman Chokus.
Thank you, Mr. Speaker. Ladies and gentlemen, I bring before you House Bill 808, and simply it deals with tangible personal property, which is a specific type of property tax that applies to personal property. Currently, the exemption is for $7,500, and we're planning on raising it to $20,000. It hasn't been raised in years, and the reason we're doing this is to compensate for inflation. And that's it. Thank you, Mr. Speaker. If there are any questions, I'll be happy to answer one or two.
Gentleman has no questions.
Thank you, Mr. Speaker. I appreciate a favorable consideration for this bill.
Good explanation. The gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? Chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? All members voted. If so, the clerk will lock the machine. On the passage of House Bill 808, the yeas are 125, the nays are 42. The bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption to House Bill 1090?
House Bill 1090 by Representative Newton of the 127th and others to be entitled an act to amend Article 2 of Chapter 7 of Title 48 of the official code of Georgia annotated relating to imposition rate computation exemptions and credits relative to income taxes. This bill having referred to the Committee on Ways and Means, that committee recommends that this bill do pass by committee substitute.
Gentleman from the home of the masters, Augusta, GA, Representative Newton is recognized to present the bill.
Thank you, Mr. Speaker. Colleagues, I bring before you today House Bill 1090. This bill's on a foundation that was started a couple of years ago in the Fostering Success Act. We know that children that are in foster homes are some of the most challenging situations across our state that are in such need. What we find out when we pass that bill is that their needs don't end when they turn 18 and they're officially out of foster care. So we do have the Fostering Success Act. Today's bill, House Bill 1090, kind of augments and improves that previous legislation. It more clearly assists former foster children ages 18 to 21, and it helps them make a successful transition to adulthood. House Bill 1090 does that with three primary items. It cleans up language regarding eligibility of at-risk youths who could benefit from this. For example, it allows youth who turn 18 or graduate from high school, say in May. They're not attending a vocational school until sometimes July or August, so we changed attending to enrolled. We're just trying to clean up definitions rather than leave kids out there with no support, no mentorship, and no assistance while they're waiting a couple of months there in the summertime, things like that. Second thing it does, it more clearly defines what mentorship is. There's need with nutrition, with transportation, with housing, so many things that are important, but mentorship is a key part of this, and so it better clarifies what it means to be a mentor and to be, in lieu of a parent, the one who can help these young youth advance. Second thing it does, it opens up the definition a little bit of the types of corporations and entities that can donate to this program. There was a $20 million maximum. We didn't even raise half that with regular income tax. There is a provision in here that allows some companies that owe other things like premium taxes to participate in this program to help youth coming out of that. Finally, this bill does put some guardrails around the spending of this money. There's a lot of great organizations that help foster children. The state itself has some great programs and some great individuals that we all know about that make such a difference in these challenging situations. We wanted to put guardrails to where this is new money that doesn't just go for overhead somewhere, but the bill specifies that at least 80% of the money will go directly to the children, at least 80%, hopefully more, so that they can adequately get the care they need. I appreciate your support on this. I think it's a good step forward. I wish I could tell you about the examples of kids that have been helped by this. Maybe we'll get to that one day. I know Representative Hutchinson does a great job with that with us, but I'd appreciate your support, Mr. Speaker. Glad to answer any
The
questions.
gentleman has a question. Representative Kennard to your left is recognized for a question.
Does the gentleman yield?
I do.
Isn't it true that in my transitional program for the homeless that we get a steady stream of individuals who have aged out of the foster care system and they're often broken by the system, and measures like this will help turn that around?
I think the gentleman is absolutely correct and knows of what he speaks. Thank you, Mr. Speaker. I yield the will.
Gentleman had no further question. He's yielded the will. Is there an objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there an objection to adopting the committee's substitute? Chair hears none. The committee's substitute is adopted. Is there an objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And Mr. Clerk, will you unlock the machine? Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 1090. The yeas are 168. The nay is 1. The bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption of House Bill 1028, 1028?
House Bill 1028 by Representative LaHood of the 175th and others to be entitled an act to amend Title 20 of the official code of Georgia annotated relating to education so as to repeal the requirement of screening of public school children for scoliosis. This bill having referred to the Committee on Public and Community Health. That committee recommends that this bill do pass by committee substitute.
Chairman LaHood is recognized to present the bill.
Thank you, Mr. Speaker and members. So the caption to the bill, that portion of the bill has actually been removed. So the scoliosis screening will still be happening in schools unless the bill gets changed, further later this legislative session. However, the Department of Public Health did recommend that practice cease. But this is a department cleanup bill brought to us from Dr. Toomey, and it basically clarifies rules and regulations around adding definitions, adding certain drugs to the Commissioner's standing order, and revising outdated code, such as the requirement of the department to approve and issue mass gathering permits, which was put into place way back in response to the Woodstock Music Festival. So we felt like it would be a groovy idea to remove that since it hasn't been used in all these years. Mr. Speaker, I'll take any questions if there are any.
I think you just answered them. You have
All
no
right.
questions.
I'll yield the well, thanks.
The gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair has done. The previous question is ordered. Is there any objection to agreeing to the committee substitute? Chair has done. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? Chair has done. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And Mr. Clerk, will you unlock the machine? Have all members voted? All members voted? If so, the clerk will lock the machine on the passage of House Bill 1028. The yeas are 167, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption to House Bill 1247, 1247?
House Bill 1247 by Representative Lever to the 123rd and others to be entitled an act to amend Title 44 of the Official Code of Georgia Antietam relating to property so as to provide for a transfer on death deeds. This bill having referred to the Committee on Judiciary, that committee recommends that this bill do pass by committee substitute.
Chairman Leverett is recognized to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen, House Bill 1247 is probably one of the most seemingly boring bills that will be of the most consequence to you and your constituents this year. It allows for a vehicle called transfer on death deeds. This was first, to my knowledge, proposed by Representative Lim some years ago, and I think it's a great idea. It basically allows you to execute a deed to provide that real estate will pass to certain beneficiaries at your death. Now, there is a form of deed by which you can do that now. It's basically conveying a remainder interest and reserving a life estate with a power of sale and a right to counsel and revert. But that takes a bit of time and a bit of complexity to draft. In this code section, the statutory framework is established where you can execute the deed and the form of the deed is set out in code. You can change the designation or you can revoke the designation. And there's a process by which the beneficiary can accept at your death. So this simplifies it, it streamlines it, and it's much more accessible to people. It provides them with a will substitute when they may not have sufficient funds to pay for estate planning or preparation of what is a fairly complex, sophisticated deed. So I would recommend it to you highly. I think it's a great consumer protection and a great consumer advantage. It's a good vehicle to provide for your constituents, and it provides them an alternative when they might not be able to afford a more intensive kind of estate plan. So I would request your favorable consideration of this bill, and I will be glad to answer any questions.
The gentleman has a couple of questions, if you'll yield.
Yes, I'll yield.
Representative Reese, Representative Teddy Reese has a question to your left.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir.
Sir, isn't it true that in some of my free time I write wills and healthcare narratives for seniors through the Georgia Legal Services Program, and this will be a great tool to help them and solve a lot of their problems with trying to handle their property upon their demise?
As we're fond of saying in this room, the gentleman knows of what he speaks.
And does the gentleman further yield?
I'll yield, yes, sir.
My last question, sir.
For a question like that, I'll keep yielding.
Yes, sir. For my support on this bill, can you promise me I will not have to go back to law school and learn how to write these deeds and take the bar again?
Yes, I promise you, because we got the form set out in the code for you.
Yes, sir. Thank you, sir.
Thank you for the question.
Okay, you have one further question after you legal eagles completed your discussion. We're going to have some common sense question from an ag guy over here. The chairman of ag, Representative Dickey, is recognized for a question.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir, Mr. Chairman.
This is not an ag question, but if there's a conflict with this document and a will, what has precedent? I'm sorry I didn't ask you before, but what takes precedent?
Well, the statute actually provides that you can't revoke the conveyance by a will, and the will would take precedent, which it generally does. If you make a lifetime transfer of property that you have left to someone in your will, the gift is considered a deemed. It just kind of lapses and goes away. The same effect here. So you would have to execute another deed or a change of designation.
Thank you. I hope some other folks understood that better than I did.
Yeah. That was some of that legal stuff right there I'm talking
The
about.
answer to your question, Mr. Chairman, is yes.
Now, that's the kind of question I can understand the answer. You have no further questions.
Thank you, ladies and gentlemen. I would request your favorable consideration of House Bill 1247. Thank you. Thank you, Mr. Speaker.
The gentleman has yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee's substitute? The chair hears none. The committee's substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And the clerk will unlock the machine. Have all members voted? If so, the clerk will lock the machine on the passage of House Bill 1247. The yeas are 171, the nays are 0. The bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption of House Bill 1264, 1264?
House Bill 1264 by Representative Stevens of the 164th and others to be entitled an act to amend Title 43 of the Official Code of Georgia Annotated relating to professions and businesses so as to authorize the Georgia Composite Board of Professional Counselors, Social Workers, and Marriage and Family Therapists to establish a professional health program. This bill having referred to the Committee on Health, that committee recommends that this bill do pass.
Chairman Stevens is recognized to present the bill.
Thank you, Mr. Speaker. Ladies and gentlemen of the House, I bring you House Bill 1264, which is an alternative to discipline program for nursing programs. House Bill 1264 will authorize the Board of Nursing and the Composite Medical Board of Professional Counselors to create a program that exactly mirrors what physicians, pharmacists, and dentists already have today. Georgia is only one of 7 states that do not have an alternative to discipline program for the licensed professional nurses, and none of these states are in the South. This program will enhance the patient's safety through early detection, intervention, and contractual monitoring agreements before a nurse practice can negatively be impacted. In this day and time, whenever we have a real scenario of shortage of nursing, we need to be able to intercede in an early stage so that we can help these nurses get back to practice and monitor these through their discipline program. Mr. Speaker, if there's no questions, I'll ask for your favorable consideration.
The gentleman has no questions.
Thank you.
Gentleman has yielded the well. Is there any objection to the previous question being ordered? Chair hears none. The previous question is ordered. Is there an objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? All members voted. If so, the clerk will lock the machine on the passage of House Bill 1264. The yeas are 171, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption to House Bill 1040, 1040?
House Bill 1040 by Representative Hilton of the 48th to be entitled an act to amend Article 13 of Chapter 1 and Title 7 of the Official Code of Georgia Annotated relating to licensing of mortgage lenders and mortgage brokers so as to prohibit unfair or deceptive practices. This bill having referred to the Committee on Banks and Banking, that committee recommends that this bill do pass by committee substitute.
Representative Hilton is recognized to present the bill.
Thank you, Mr. Speaker. Members, I present to you House Bill 1040. This bill deals with mortgage trigger leads. When you apply for a mortgage through your lender, they run a credit report that's sent to the credit agencies who then sell that data out to other lenders. And then you as a consumer are left with all these inbound calls of, hey, I hear you're looking for a credit, would like to deal with you. This doesn't outlaw that. It says you can still do unsolicited leads. You just have to follow these 4 parameters that we've outlined in the legislation. I want to thank Floor Leader Wade for bringing this idea to me. It's an honor to be a proxy of a floor leader and be before you today. So I ask for your consideration and will yield for questions.
You have no questions.
Thank you, Mr. Speaker.
Gentlemen, is yielded the well. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair hears none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? For what purpose does Representative Wiedauer rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that if the gentleman had yielded this legislation to the governor's floor leader, that presentation would have taken 5 times as long?
I'm really proud he didn't, if you feel that way. It makes me feel better, but not much better. Mr. Clerk, will you lock the machine? On the passage of House Bill 1040, the yeas are 169, the nay is 1. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption of House Bill 1100, 1100?
House Bill 1100 by Representative New, the 64th, and others, to be entitled an act to amend Title 40 of the Official Code of Georgia Annotated relating to motor vehicles and traffic, so as to authorize the use of electronic notifications and communications by the Department of Revenue to motor vehicle owners relative to motor vehicle registration. This bill having referred to the Committee on Motor Vehicles, that committee recommends that this bill do pass by committee substitute.
I think the lady knows a little bit about this subject matter, doesn't she? She certainly does. Representative Kimberly New is recognized to present the bill.
Thank you, Mr. Speaker. Colleagues, I appreciate the opportunity to talk to you today about HB 1100. This is an agency bill for the Department of Revenue, the motor vehicles. This bill does 4 things. Number 1, it allows the Department of Revenue and the Department of Driver Services to send electronic notices or emails to customers who choose to opt in to receive notices. Customers like me wishing to continue to receive paper notices can still do that. It is an opt-in option only. Number 2, it clarifies that all vehicles titled to a government entity will have a plate labeling it is a government vehicle. This does not apply to law enforcement vehicles. This is for transparency in tax dollars. Number 3, it allows trailers to be included in the definition of fleet for vehicles that can have the registration renewed in bulk. So the definition of fleet is that you have 100 motor vehicles or more. So this is, would speed up the renewal process for those entities to renew their fleet. And that is like U-Haul, Avis, those are the individuals, the entities that would be able to do so. The 4th thing it does is to provide statutory authority for the Department of Revenue to allow electronic transfers of titles. It's setting the foundation for the future of Georgia for e-titling. Other states are already moving towards paperless title, and this would set us the foundation for the future for us to do the same. This is what the bill does. I would ask for your favorable consideration if there are no questions.
Lady has a couple of questions if you'll yield.
I will.
Representative Hughley to your left has a question. Representative Hughley.
Thank you, Mr. Speaker. Does the gentle lady yield?
I will.
Just a point of clarification. So you're saying all government vehicles have to have a government tag unless they're law enforcement. Is that what you're saying?
That is correct.
Well, does the gentle lady further yield?
I yield.
Isn't it true that some officials have taken the government tag off for their safety, and they've gone to just regular tags so that they won't be identified or harassed as they move around the city or the state? So that's a concern that I would have. Is that not true?
So this is for transparency and tax dollars. So taxpayers are paying for that vehicle, and so that way the taxpayer will know that that is a government vehicle, yes.
Does the gentle lady further yield one more time?
One more question, yes, ma'am.
Let me just bring it home for you.
Okay.
Isn't it true that my husband is the city manager of the city of Columbus, Georgia? They took off his government tag for his safety and gave him a regular tag. And you're saying that they're going to have to go back and put the government tag back on. Is that the correct understanding?
That does cover the scope of this bill, but I will say you probably do have a personal car that he could probably use.
Lady, yield for another question.
Can I yield the well, sir?
You may, yes. If that's
I
the
would
lady,
like to
sir.
yield the well.
The lady has yielded the well. Is there any objection to the previous question being ordered? Chair has none. The previous question is ordered. Is there any objection to adopting the committee substitute? The chair has none. The committee substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair has none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? For what purpose does Chairman Mitchell rise?
Mr. Speaker, isn't it true? I wish that the lady would have remained in the well so that I could ask the question. Isn't it further true that judges, clerks, and others in the times that we live in would have to display their government cars, DAs? There's a bill that is working its way through the legislative process now that would remove their ability to list their personal property. And some of us, if this bill were to pass, those judges, DAs, and the like would have to display their government cars.
I'm sure the gentleman knows what he speaks, and evidently, as you speak, there's another bill working its way, so hopefully we'll get to a good final product at the end of the day. All members voted. Mr. Clerk, will you lock the machine? On the passage of House Bill 1100, the yeas are 99, the nays are 68. The bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption of House Bill 957?
House Bill 957 by Representative Petrie of the 166 and others to be entitled an act to amend Article 3 of Chapter 7 of Title 52 of the Official Code of Georgia Annotated relating to abandoned vessels, shows revised penalties for failing to remove an abandoned vessel. This bill having referred to the Committee on Public Safety and Homeland Security, that committee recommends that this bill do pass by committee substitute.
Representative Petrie from down on the coast is recognized to present the bill. Chairman Petrie.
Thank you, Mr. Speaker, and I think we have a visual aid here, folks. Ladies and gentlemen, I bring you today House Bill 957. This bill was is brought to you by myself and co-sponsored by my entire coastal delegation in this caucus. This bill deals with abandoned and derelict vessels. So just let me tell you a little bit about the problem. We have a multitude of abandoned vessels in Georgia waterways today. There are currently, according to DNR, 159 abandoned vessels. You see some examples here on the Georgia coast. There are 38 abandoned vessels in Georgia lakes. About half of these are sunken. Some are above water, some aren't. But as you can imagine, they are a real risk to public safety in terms of navigating public waterways. It costs the department about $32,000 to $42,000 to remove some of these, as you can imagine, and that burden is now borne by taxpayers, and we don't really have a line item for such removals in the first place. So, to date, what you need to know is this. To date, the department has not found a path to hold people accountable for this. My friends, people are floating vessels down here from other states and floating them off into the sunset. In my district, between sessions this year, we had a vessel from New Jersey that was floating in the Skidaway River. The guy floated it down here from New Jersey and literally just walked away and left it. These are vessels that have no value. They're barely worthy of floating any longer. And rather than deal with them appropriately, they just float them off into the high marsh, or in some cases sink them in the channel. This is a huge problem for the department. What this bill does very simply is once and for all fix this problem. This creates a penalty. It creates a criminal penalty of a misdemeanor and a high and aggravated nature. First offense, second offense is a felony. And further, it allows DNR some other measures you'll see in here, allows them to revoke vessel fishing licenses, and it allows the Department of Revenue, for an individual that does this, to revoke an automobile license, a driver's license, much as we do with some of the other abandoned issues with cars on highways. So to my colleagues here today, this is an issue of great importance to us on the coast. There is an exception you'll see in here that came from the wisdom of Representative Jaspers. In a state of emergency where you have a hurricane, there's an exception for that. And Mr. Speaker, I think that fairly explains the conundrum, and I'm glad to answer any questions.
You have a coastal question if you'll accept it.
Yes, sir, Mr. Speaker, glad
Just
to.
further down the coast from you, Chairman Saines to your left.
Thank you, Mr. Speaker. Does the gentleman yield?
Yes, sir, I yield.
Is it not true that this will allow some of our friends in our coastal delegation to avoid sandbars because they're not as distracted by abandoned vessels?
I think that's fair. I think that's very fair. Yep.
One last question. Representative Franklin, right out in front of you to your right, has a question.
Thank you, Mr. Speaker.
Thank you. Is it not true that I'm a ship's captain?
It is. That's my understanding.
And one of the very first things I learned that our beautiful coastlines are not a dumping ground?
That is right, Representative, and indeed, people are using the Georgia coast today and Georgia lakes as a dumping ground for this material. Thank you for the good question. Thank you, Mr. Speaker. I yield the well.
I think that last boat he captains, that blue one up there in the top left-hand corner, maybe is his last boat. That's why you lost your license to be a captain. Is there an objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there an objection to adopting the committee's substitute? The chair hears none. The committee's substitute is adopted. Is there an objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no, and the clerk will unlock the machine. Have all members voted? All members voted. If so, the clerk will lock the machine. On the passage of House Bill 957, the yeas are 170, the nays are 0. This bill, having received the requisite constitutional majority, is therefore passed. Mr. Clerk, will you read the caption to House Bill 481, 481?
House Bill 481 by Representative Carson of the 46th, to be entitled an act to amend Article 7 of Chapter 20, entitled 47 of the Official Code of Georgia, annotated the Public Retirement Systems Investment Authority Law, so as to provide for a fiduciary duty to invest retirement assets. This bill has been referred to the Committee on Retirement. That committee recommends that this bill do pass by committee substitute.
Chairman of the Committee on Retirement, Chairman Carson, is recognized to present the bill.
Thank you, Mr. Speaker, and I know the hour is getting late. House Bill 41, all this does is codify the fiduciary duties and investment policies as set forth by our employee retirement system and the teacher retirement system. These fiduciary rules were adopted by their respective investment committees in September of 22 and adopted by the board formally in October of 22. All it does is mandates that fiduciaries execute their duties solely in the interest of plan members and beneficiaries. It ensures that every decision they make regarding retirement assets is made with the well-being of those individuals in mind. It requires fiduciaries to vote and execute on all voting proxies in the best interest of the investors. It very simple, just codifies the board rules that are already been in place for the past year and a half, and it represents a step forward in ensuring the integrity and security of our state retirement systems. And that's all the bill does, Mr. Speaker. With that, I will yield for a question if there is one, and if not, I will yield the well.
You have no questions.
Thank you, Mr. Speaker. I yield the well.
We do have a couple of members that are opposed to the bill that have requested time to speak. Per the rule, from the Rules Committee, they have up to 30 minutes. We will recognize Representative Sandra Scott to speak to the bill. Representative Scott.
Thank you, Mr. Speaker. Today, I stand before you to voice my opposition to House Bill 481, a bill purportedly aimed at safeguarding retirement assets in Georgia. While the bill claims to prioritize the financial interests of retirees, it fails to recognize the broader implications and risks associated with the provisions. First and foremost, House Bill 481 seeks to ensure retirement assets are managed solely in the financial interests of participants and beneficiaries. While this may sound appealing on the surface, it neglects the reality that retirees have diverse needs and interests that extend beyond financial gains. By focusing solely on financial interests, this bill could restrict investment opportunities that may align with retirees' values and social well-being. Furthermore, the bill imposes stringent fiduciary duties, mandating fiduciaries to act prudently and diversify investments to minimize risk. While prudence and diversification are crucial, the bill fails to acknowledge the potential administrative burden this places on fiduciaries. The increased bureaucratic hurdles could hinder timely decisions making and limit the agility needed to navigate dynamic market conditions effectively. Additionally, House Bill 481 prohibits sacrificing investment returns for non-financial interests, such as social or political agendas. While financial returns are undoubtedly important, so too are the ethical and societal implications of investment decisions. By prioritizing financial gains above all else, the bill ignores the potential for investments to contribute positively to societal progress and environmental sustainability. Moreover, the bill allows for the delegation of investment management to qualified professionals. While expertise is valuable, delegating such responsibility introduces complexities in accountability and oversight. There is a risk that fiduciaries may abdicate their responsibilities without adequate scrutiny, potentially exposing retirees to undue risk or conflict of interest. In conclusion, House Bill 481 fails to strike a balance between financial prudence and broader societal interests. It emphasizes on financial gains, overlooks the holistic well-being of retirees and the community at large. Therefore, I urge you to reconsider this bill and advocate for legislation that prioritizes the comprehensive needs and values of Georgia retirees. Thank you, Mr. Speaker, and I yield the well.
Lady is yielded the well. Representative Jasmine Clark is recognized to speak to House Bill 481. Representative Clark.
Thank you, Mr. Speaker. Today I rise to express my concerns about House Bill 481 and to ask you to vote no on House Bill 481. Specifically, at lines 39 through 40, this bill points out that pension funds or fiduciaries for pensions cannot, and they cannot consider non-pecuniary interests or financial, I had to look that word up myself, but shall, and these non-pecuniary interests include things like social, political, or ideological interests. And so whenever there is anything in a bill or law, there's usually a reason for it. So I asked myself why. Why were these words specifically written into this bill? Why would we specifically not want pension or fiduciaries for pensions to consider these things? And I found some remarks from the committee testimony on this bill from a libertarian lobbying organization in which they accuse activists and elected officials of pressuring public pensions to invest or divest from specific companies or industries. So this is an overly simplistic view that has the potential of actually limiting options for alternative investments for Georgia pensioners, based on the assumption that it is for reasons other than financial reasons. Is it not possible that divestment from certain industries can be both a good financial decision as well as good social policy? And if so, who is going to decide how these fiduciaries are acting? Who gets to be the final arbiter on whether an investment is non-pecuniary or not? For example, many investment firms consider environmental, social, and corporate governance criteria, also known as ESG, as a part of their decisions on investment. This does not mean it is the sole criteria. It is a part of the criteria that they consider. And if you take this into account, that does not necessarily decrease the total number of potential alternative investments. However, the bill that we are voting on today does have the effect of taking certain alternative investments off the table, lest an investment company be accused of pushing a, quote, woke agenda. Additionally, sometimes divestment is the right thing to do. For example, in 2022, our governor decided to divest from Russian firms after Russia's aggressive invasion of Ukraine. This bill would take options like that. For Georgia to stand on its values, it would take those options away. We could be forced to continue investments in firms and countries committing acts that we do not agree with. Why would we want to tie our hands this way? Lastly, this is essentially an anti-climate change solutions bill. If you live anywhere in South Georgia or places where you have been affected by things like hurricane, then you know that climate change, unaddressed, has the potential to cause devastating effects on our economy. Increased flooding, severe storms, drought can cost communities lots and lots of money. So considering the impact of climate change in our state's retirement portfolio is very much a financial decision for our state. We should be doing the absolute most to make sure that our alternative investments are going to give pensioners a good return on investment when they retire. Labeling certain investments as, quote, woke, or assuming that certain investments or divestments are based solely on political activism risk causing pensioners to not get as much as they could and even possibly lose money. I urge you to vote no on this legislation because we should not be using this chamber and we should not be using the law to decide who gets to be who we get to invest in for our pensioners. And with that, Mr. Speaker, I yield the well.
The lady has yielded the well. That concludes the speakers on House Bill 481. Is there any objection to the previous question being ordered? The chair hears none. The previous question is ordered. Is there any objection to adopting the committee's substitute? The chair hears none. The committee's substitute is adopted. Is there any objection to agreeing to the report of the committee, which was favorable to the passage of the bill? The chair hears none. The report of the committee is agreed to. Shall this bill now pass? All in favor of the passage of the bill will vote yes. All those opposed will vote no. And the clerk will unlock the machine. Have all members voted? For what purposes, Representative Rahman rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that I was approached by several members of law enforcement that asked me to vote no on this bill?
If the lady will hold just for a minute. Please restate your inquiry.
Is it not true that I was approached by members of law enforcement who asked me to vote no on this bill, and they specifically cited concerns with retention?
I'm sure the lady speaks truthfully. For what purposes, Representative Franklin rise?
Parliamentary inquiry.
State your inquiry.
Is it not true that this bill simply codifies common sense, namely that our retirement system must be managed to serve the financial interest of its members?
I'm sure the gentleman knows that common sense is not so common anymore, but he believes in what he speaks. For what purposes, Representative Jason Ridley rise?
Parliamentary inquiry.
State your inquiry.
Mr. Speaker, is it not true that the lady talked about the law enforcement approaching her? That's a different retirement bill that they are looking at, not this one.
I'm sure you may be right. I'm not sure. I'm not sure what they spoke to the lady about. Mr. Clerk, will you lock the machine? On the passage of House Bill 481, the yeas are 114, the nays are 51. This bill, having received the requisite constitutional majority, is therefore passed. Thank you, members. We have completed our rules calendar. We'll now move on to afternoon orders. We will have a maximum of 1 minute. Maximum of 1 minute this afternoon. We have a couple of afternoon orders that members will need to pay attention to and give the respect. Representative Martin, do you have an afternoon order that you would like to do today? You had spoken to us earlier about that. Representative Daniel, I know you have one. I pretty much used up my 1 minute, so here we go. Representative Howard and the Augusta delegation is recognized. They're recognized for an afternoon order. Representative Charlton Howard, the Augusta delegation.
Thank you, Mr. Speaker. On behalf of my colleague, Representative Gloria Frazier, I stand in her place for our Black History moment, representing Black history. And today we rise to pay tribute to the legend that I had the opportunity to meet on several occasions. James Brown, the godfather of soul, not only left an indelible mark on the music world, but he also made significant contributions to race relations. Born and raised in Augusta, Georgia, James Brown was deeply connected to his hometown and used his platform to advocate for equality and for unity. In a time of racial strife and segregation, James Brown's music transcended boundaries and brought people together. His iconic song, "Say It Loud, I'm Black and I'm Proud," became an anthem for civil rights movement, empowering African Americans to embrace their heritage and stand up against discrimination. Today we remember James Brown not only as a musical genius, but as a champion for civil rights and a proud son of Augusta, Georgia.
Thank you, Augusta delegation. Representative Lauren Daniels is recognized for an afternoon order.
Thank you, Mr. Speaker. I would also like to invite my Henry delegation up here if possible. And last week, we lost a pillar in our community. Some of you may know him as the owner of Southern Bell Farms. Mr. Carter was a man of many accolades, and he spent his entire life in service in some form or another. He spent 2 decades on the Henry County Board of Education, and I think it would be fair to say that many kids, including myself, would not be where we are today if it were not for the service of Mr. Carter and his efforts to make Henry County public school system one of the best in the state. He served in the military, on the Henry County Water Authority, and numerous other boards, and was a deacon in his church. Mr. Jimmy Carter had a great passion for agriculture, and he was a farmer through and through. He gave himself fully to our community, but most importantly, the way in which he loved his family cannot be overstated. They say the measure of a man is what he leaves behind, and what Mr. Jimmy Carter leaves behind is a legacy of service and a family who has followed in his footsteps by their continued service to our community. Please join me in prayer today by lifting up his wife, Kathy, and the rest of his family, as well as our community, because he will be dearly missed. Thank you.
Thank you, representatives. Representative Hutchinson is recognized for an afternoon order.
Thank you, Mr. Speaker, and good afternoon, colleagues. Today, I'd like to introduce to you one of the hundreds of children who are available for adoption in Georgia. Please meet Cassius. Cassius is 6. He is a kind, determined, loving child who enjoys playing with cars, balls, and monster trucks. He also enjoys watching Spider-Man, Batman, and all other movies involving Batman and Spider-Man. At school, he gets along well with other kids. He enjoys reading, playing with books, and movie time. Colleagues, these are one of hundreds of children who are available for adoption, and I am a sucker for that snaggletooth smile. Thank you, Mr. Speaker. I yield the well.
Representative Glaze is recognized for an afternoon order.
Thank you, Mr. Speaker. I think I have a picture that goes with this. So I stand to do an afternoon order for African American History Month. This is Susie King Taylor, the first certified African American teacher in the United States of America. She was from Liberty County. She was born in 1848, passed at 64 years old. She started several of the first colored schools in Georgia. Upon the Civil War, she became a nurse. After the Civil War, she worked 4 years, 3 months, no pay. They did not pay a black woman at that time, or men. And so she went on to Boston and served a very wealthy family there. And upon serving there, she eventually came back to this great state of Georgia in Liberty County, and she wrote her Renaissance, her own story. So thank you so much for listening to the life of Susie King Taylor.
Good moment. Thanks for bringing it to us. Chairman Tyler Paul Smith is recognized for an afternoon order.
Thank you, Mr. Speaker. I want to take this moment and apologize to members of my House family. Earlier, when I presented a bill, I made a very insensitive reference, and that offended some, and so I wanted to make sure that I apologize to each and every one of y'all. Most of all of y'all know the intent of my heart, but when you mess up with your words, you got to correct that, and so I would ask each and every one of y'all to forgive me for that, as that was nowhere near my intent. Thank you, Mr. Speaker.
Thank you, Representative. Measure of a member when they apologize for something that may have been said or taken out of context, so thank you for doing that. Representative Stinson. You have a resolution would like some signatures on. Representative Stinson. Boy, you can get down that hall, that center aisle body fast.
Yes, sir.
Take your time. Representative Stinson.
Thank you, Mr. Speaker. Members of the House, I would just like to share with you that I have some legislation that I plan to introduce and would love to have some signatures joining in with me. And my legislation is simply providing where in any indictment proceedings before a grand jury, the accused and his or her counsel shall have the right to be presented during the presentation of all evidence. Currently in Georgia, when someone is indicted, before they are actually indicted, when their case go before a grand jury, the grand jury is only hearing from the prosecution. My simple legislation would make it where the grand jury will hear both from the prosecution and the defense. So if anyone would like to read this and look more into it and sign off with me, you are welcome to do so. So thank you. Thank you, Mr. Speaker, and I yield the well.
Lady has yielded the well. That completes our afternoon orders. Mr. Clerk, will you read the caption to a group of privileged resolutions?
Honoring the life and memory of Horace King. Honoring the life and memory of Dr. Richard Weitzenecker. Honoring the life and memory of Dr. James R. Morrow. Honoring the life and memory of William Douglas Mealing, Sr. Recognizing and commending Lady Fannie Mae Hauser. Recognizing and commending Ann McNeil. Congratulating and commending Toyo Tire USA. Congratulating and commending Nagel's Bagels. Recognizing March 2024 as Blood Clot Awareness Month at State Capitol. Congratulating and commending Lana Copeland Hardy for receiving the 2024 Yellow Rose Nikki T. Randall Service Leader Award. Congratulating and commending Tiffany McBride for receiving the 2024 Yellow Rose Nikki T. Randall Service Leader Award. Commending and congratulating Eugene H. Russell. Recognizing March 4th, 2024 as DeKalb County Day. Recognizing and commending Huma Yosef for being the first elected ethnic minority and Muslim First Minister of Scotland. Recognizing March 4, 2024 as Reach Out and Read Day at the State Capitol. Recognizing and commending Georgia State University. Recognizing February 27, 2024 as Dominican Republic Independence Day. Recognizing November 1st, 2024 is Diwali Day. Commending the Georgia, Walton, and James Oglethorpe chapters of the Daughters of the American Revolution. Recognizing and commending the Georgia Department of Agriculture upon its 150th anniversary. Recognizing March 2024 as Colorectal Cancer Awareness Month. Congratulating and commending Heather Braswell, recognizing and commending radio station VSAM 1040 on its 10th anniversary, and recognizing March 2024 as Colorectal Cancer Awareness Month and honoring the Georgia Colorectal Cancer Control Program. Recognizing and commending October 23rd, 2024 as Fentanyl Prevention and Awareness Day for Georgia students. And for other purposes, that completes the reading of the privilege resolutions.
Is there any objection to adopting the privileged resolutions? Chair hears none. The resolutions are adopted. We'll move on to announcements. Chair Lady Darlene Taylor is recognized for an announcement.
Thank you, Mr. Speaker. The Life and Health Insurance Subcommittee will be meeting immediately upon adjournment in room 415. 415, Life and Health Subcommittee. Thank you.
Chairman Jasper is recognized for an announcement.
Thank you, Mr. Speaker. 406, transportation members, I need you. We've got these very important road naming to get through and also another couple bills. So I need you to be there if you can. Thank you, Mr. Speaker.
Chairman Powell recognized for an announcement.
Regulated Industry Committee, room LOB 606. Ways and Means will have it before us. Chairman Blackman says they'll be there about 30 minutes. So I'm guessing in about 30 to 40 minutes, if you'll show up, we've got some very important stuff and need for you to be there to hear Al Williams present a cosmetology bill.
Most difficult bills in this of all time, cosmetology, no doubt. Chairman Corbett recognized for an announcement.
Thank you, Mr. Speaker. The Environmental Quality Subcommittee of Natural Resources will meet in room 415, CLOB, upon adjournment. And also the hardest working committee in the chamber, Mr. Speaker, the Motor Vehicles Committee, will meet tomorrow morning at 8 o'clock in 606. Thank you.
Chairman Meeks recognized for an announcement.
Thank you, Mr. Speaker. Budget and Fiscal Affairs will meet upon adjournment in 341. Budget, Fiscal Affairs upon adjournment 341. Thank you, Mr. Speaker.
Representative Hong is recognized for an announcement.
Thank you, Mr. Speaker. Judiciary Non-Civil Hong Subcommittee will meet in room 132 upon adjournment. Thank you.
Representative Anderson is recognized for an announcement.
Thank you, Mr. Speaker. Governmental Affairs will meet upon adjournment of transportation in 406 CLOB. Thank you.
Chairman Mitchell recognized for an announcement.
The Democratic Caucus will meet tomorrow morning, 8 a.m. in 2:30. Breakfast will be served. Thank you, Mr. Speaker.
Chairman Newton recognized for an announcement.
Thank you, Mr. Speaker. Two committee announcements. House Health will meet immediately on adjournment in Capitol 403, just upstairs. On adjournment of House Health, Interstate Cooperation will meet. So also in 403. Thank you, Mr. Speaker.
Chairman Lumsden recognized for an announcement.
There will be a meeting of the Full House Insurance Committee meeting in the morning, 8 a.m., CLOB 406. Thank you.
Chairman Stevens recognized for an announcement.
Thank you, Mr. Speaker. Tomorrow morning at 8 a.m., the House Economic Development and Tourism Committee will meet in 506 CLOB.
That completes our announcements. Members, if you'll cast your eyes up on the message boards, this is something new that the messenger has coordinated. You will have your pages identified and the representatives they are serving on the board. I appreciate them doing that. That's special. So our pages, we'll do it a little bit earlier. They can see their names up in lights. That completes the business of the day. This House's majority leader is recognized for a motion.
Thank you, Mr. Speaker. I move that this House stand in recess until 6 o'clock p.m. and then stand adjourned until 10 a.m. on Tuesday, February 27th, 2024.
On the motion of the majority leader, this House stands in recess until 6 p.m. today, and then stand adjourned until tomorrow, Tuesday, February the 27th, 2024 at 10 a.m. All those in favor will say aye. All those opposed will say no. The ayes clearly have it. We're in recess.